I would like to mention item number 11.
Okay.
I pray for an adjournment for 2 weeks, you know.
Okay. Your name?
P. Sengupta.
Learned Counsel Mr. P. Sangupta, with the consent of the other side, has prayed for adjournment. How old is the case? Item number 11.
It's 25.
Okay, list the matter after 3 weeks.
3 weeks. 2 weeks. you know.
2 weeks.
May it please your lordship.
Oh.
My lord, I beg to mention item number 18 of today's list, lordship.
18.
18. I have a consent from the other side, lordship. I pray for 2 weeks time, lord.
You have taken consent, no?
Lordship.
Learned Counsel Mr. K. Muzumdar,
Lordship.
with the consent of the other side, has prayed for adjournment. List the matter after
3 weeks, lordship.
3 weeks.
Lordship.
May I please, your lordship. My lord, I have filed an IA, my lord, in connection to MSc appeal on, my lord, 18/11/2025.
Oh.
It is not being listed, my lord. May I pray for listing this IA, my lord?
Today?
Not today, my lord, on 30th.
On 30th? এইটো আনছা নেকি বাৰু এই হেৰি ডেট 30th হ'বনে একমডেট কৰিবলৈ? হয়, okay.
Obligation.
Similar prayer for adjournment, my lord, with consent of the, my lord, others.
Mm.
Exponent, item number 10, my lord, 2 weeks, my lord.
I had to be listed. I had to be listed.
Adjournment, my lord. for
Oh,
adjournment.
adjournment, okay. Learned Counsel Mr. Ellen Dihinga, with the consent of the other side, has prayed for adjournment.
Lordship,
List the matter after 2 weeks.
2 weeks. Already consent, my lord,
Mm.
any council, my lord. Obliged.
Yeah, please, your lordship. I beg to mention item number 16, my lord.
Hmm.
Can this matter taken after 2 weeks, my lord?
Learned Counsel Mr. D. Bora has prayed for adjournment. List the matter after
2
on
weeks. This is
16.
a bail matter, my lord.
List the matter on when do you want?
After 2 weeks, my lord. Any date?
2 weeks or date attack?
For the first week of February, otherwise, my lord.
Okay, first week of February, 6th of February.
My lord. Deeply obliged.
May I please, your lordship? I beg to mention for listing one first appeal from orders matter, lordship. For Friday, lordship, fresh matter, lordship, motion is this.
Fine.
Filed on
Okay.
22.
Yeah.
Deeply obliged.
I pray for listing MSc appeal, any date of February, your lordship.
February,
Any date.
any date, MSc.
Fifth.
May I please, lordship?
Hmm.
I'd like to mention one CRP matter
Mm.
for admission in the 3rd week or 4th week of February, lordship. At any date in the 3rd week or 4th week.
3rd week or 4th week, date attack.
Because argument stage is being deferred because of the pendency before Honorable High Court. 25th. 20th.
May I please, lordship?
Obliged.
Prayer for listing, lordship. For orders, lordship. Lordship, Monday.
Monday for orders.
May it please, your lord.
Hmm.
Lordship, I would like to mention for adjournment, my lord. Item number 9 of today's list, my lord. I have taken the consent. However, there is an interim order which may be extended till the next date of listing, my lord. For 4 weeks, my lord. This learned senior counsel is having some difficulty, my lord.
Learned Counsel Mr.
I am K.R. Borua, ma'am.
K.R. Borua, with the consent of the other side, has prayed for adjournment. List the matter on. You want a date?
After 4 weeks, ma'am.
List the matter after 4 weeks. Okay.
Till then, the interim may be continued.
Interim order shall
Very
remain in force till the next date of listing.
In the IMX.
May I please, lordship?
I had to give you, huh? I had to give you. Yes, yes.
Lordship, I beg to mention listing of RFA 108/18 on 30th of this month.
2nd of February?
Your lordship, it's a urgent matter, so first week of February, if it's 2nd. 2. Okay.
Lordship,
Hmm.
I beg to mention one test case 7/2016. Since 2022, it has not been listed.
When do you want?
After 1 week.
After 1 week. Date attack reduction.
May it please, your lordship?
Mm.
Your lordship, I beg to mention 3 MFAs.
Mm.
All the MFAs are at hearing stage, your lordship. And these MFAs are
3 MFAs. Hmm.
Hearing.
Hearing stage.
Yes, your lordship.
Oh, hearing or date attack, when do you want?
Your lordship,
How old is the case?
ma'am, one is of 2023, other one is 2018, another one is 2019.
Same day you want 3, they are analogous matters.
Yes, ma'am. Yes, your lordship.
Analogous matters. You want it on 4th?
Fourth week of February.
Fourth
Third-
week of February.
third or
okay,
fourth
okay.
week.
Yes, yes, can be given. Fourth week of February.
সব মানে railway claims সব
Okay, হেৰি 24
Net-
27 24 নাইবা ಇದು Tuesday হবে না 24 নাইবা 26 which day do you want
26.
26
as per your lordship.
okay
Any date
26
of like.
May it please your lordship, I beg to mention one IA civil for injunction to be listed in the orders column for 2nd of February, your lordship.
on second
Your
are
lordship,
you second all right
your lordship.
Your Lordship, may I plead for adjournment of item number. My lord. We have informed the other party.
you have taken consent from the other side
Yes, my lord.
okay your name
There's a public show. It's under Anjana. Chaudhary.
what is your name
There's a public show from the respondent side.
you write down your name huh learned counsel Mr. So and so on behalf of whom
On behalf of the respondent, Anjana Chaudhary.
AG Chaudhary
Yes, ma'am.
on behalf of learned counsel Miss or Mr.
Miss.
Miss AG Chaudhary, with the consent of the other side, has
Yes,
paid
my
for adjournment. List the matter when do you want?
After 2 weeks.
After 2 weeks.
Hello.
All right.
Much obliged, my lord.
May you please your lordship, I beg to mention 2 MSc appeal for orders next week, lordship.
Next week. Data details. Fourth.
May it please your lordship.
Hmm.
I beg to mention for listing of a bail application for tomorrow, your lordship. Your lordship, actually tomorrow, item number 1 in your lordship's code only. A bail application arising out of the same FIR of the co-accused is pending.
All
your
right,
lordship.
all right. Okay.
Tomorrow-
Same, arising out of same
Same
cause of action.
Same cause of action.
Okay, all right.
Obliged.
What's with consent of other side, lordship, I beg to mention item number 2, lordship. Matter may be adjourned for the day, lordship.
Lordship, my senior won't be here in the first week of February.
Hmm.
So kindly list the matter on the 2nd week of February. Okay.
Learned counsel, Mr.
H Islam.
H Islam, with the consent of the other side, has paid for adjournment.
Okay.
List the matter on.
2nd week of February.
Hmm.
May I please the lordship, I beg to mention item number 30 on my lord. My senior is
31.
unavailable, yes, my lord. So 31,
Adjournment.
yes, my lord.
Adjournment at order stage.
Yes, my lord.
Why?
My lord, we have already taken a step, start, my lord. So services awaited.
Okay. Your name?
R.I. Bhuya.
Learned counsel, Mr. R. Bhuya has prayed for adjournment, list the matter after 4 weeks.
Yes, ma'am.
Yesterday you have taken steps, that's why I'm
Yes,
giving
ma'am.
4 weeks.
May I please your lordship, I beg to mention for listing a CRPIO on 2nd of February
CRP IO,
for admission, my lordship.
2nd of February, finally. 3rd of February.
Obliged.
May it please your lordship. My lordship, I beg to mention for listing of an MSc appeal for hearing. My lords, perhaps on the 3rd of February.
No
Tuesday.
way. Some hearing of data. 24th of February.
24th,
Mhm.
my lord. Perhaps on a shorter date though. On the second week of
Shorter
February.
dates happen.
Yes, okay. Obliged.
So we got that, so. Rejected. Order will be uploaded, you'll check it out.
May I please your lordship. Lordship, may kindly pass over the matter for time being, my senior is coming.
Item number 2, কিবা adjournment ললে হ'ব না। একেই নেকি? নহয় একে। কিবা লিভ এপ্লিকেশন আছে নেকি? নাই। Leave application আছে হবে। Petitioner is not represented. List this matter after 2 weeks.
May I please, Your Lordship? Actually, today, my lord, I'm sorry, I'm not with file, my lord. The case was actually MSCT award was given and directed to deposited before the registry, my lord. They given partly, my lord, that the principal part has been given and the interest has not been given. That's why, my lord, that contempt case is there, my lord. It may be taken up Monday or lordship may issue notice of motion also. Annexure 3 is the High Court's order, my lord.
They will issue notice there.
My lord.
Learned counsel, Mr.
C. Goswami.
C. Goswami is present for the petitioner. Issue notice to the respondent. List the matter after 3 weeks. 3 weeks?
Well, it go to which register post, my lord. That's why, my lord, maybe
4 weeks.
4 weeks.
Not register post, speed post.
Speech put, my lord.
4 weeks.
4 weeks.
List the matter after 4 weeks.
My lord, I crave your lordship indulgence, my lord. In the matter, my lord, that has been mentioned in where I am appearing as the petitioner. Without my consent, my lord, it has been mentioned falsely stating before your lordship that the consent has been taken. That item number
Which one?
30,
Which one?
item number 38.
I have forgotten now.
Yeah, my lord, I have
Because
just asked her, my lord.
Many people have taken adjournment with
I know, my lord,
consent.
my lord, I have just asked her. She told me that, my lord, that time has been taken, stating before this court that consent has been taken from me. The matter is a little urgent, my lord.
I have noted down the names also.
My lord,
We'll
let the
find
matter,
out who-
let the matter be called up, my lord. When it
is,
reaches, my lord, let the matter be called up, my lord, then I'll submit on the merits of whatever it is. My lordship will consider.
38, no?
38, my lord.
Okay. Okay, okay. There must have been a misunderstanding.
Maybe, my lord.
Maybe
So-
language problem, I think.
So let the matter come up on, it called up when it reaches, my lord, then I'll submit, my lord.
But already I have given adjournment.
But then the problem is, my lord, if your lordship permits me to say, my lord, because I'm in the midst
Actually,
of a case. my
what
lord,
I,
have to
what
the-
I could figure out, that person, I think he has a language problem.
Perhaps, I don't know.
Ah.
But what happens in this case, my lord,
Maybe-
why
I
I'm,
don't know.
otherwise I don't, your
Understand.
lordship knows, my lord, otherwise I don't object to adjournments, my lord, if with any, my lord, difficulty, the difficulty is shown. But my problem today is, my lord, this appeal, my lord, is against the grant of an ex parte decree of divorce. And I have been told that the person, my lord, now he is, my lord, proceeding towards getting a marriage done, my lord, again.
2 weeks.
He is proceeding tomorrow, perhaps is the day when this person is again going to remarry, my lord, during the pendency of this appeal. That is why there is an urgency for this matter to be heard, my lord.
But I already have given a date. No?
Let the matter be taken up because it was your lordship was misled into, my lord, giving that they're saying that consent has been obtained. I have not given consent, my lord.
No,
Let the matter,
the person, that advocate,
my lord.
I think he was hesitant while submitting. And then when I kept on asking him, maybe there was some problem.
You can
communication problem
let it be
between the
for,
court and the
then let it be
person.
1 week, my lord. Let it be 1 week, my lord.
1
Let
week,
them
no?
correct it 1 week, my lord.
I can give a date also if you
Yes,
want.
my lord. Please give a date, my lord.
Data, did you sort data?
February. Yes, I'm deeply obliged.
My pleasure, Lordship. I'm sorry, in item number 3, Lordship, I could not appear, Lordship. Your Lordship has given the date 2 weeks, Lordship. Can it be here today, Lordship?
Yes, of course.
Yes, Lordship.
For the time being. You'll submit.
Yes, I will submit, Lordship.
Give item number 3 to here. Yes.
Lordship, this petition has been filed against the order dated 6/11/2025, Lordship. The
Itu kati diba, item number 3 to.
Annexure 9, page 29, Lordship. Whereby the Lordship learned trial court rejected the prayer for filing the written statement, Lordship, on the ground of that the limitation period is already over, Lordship. But Lordship, kindly see the date of service the notice, Lordship. That is.
Where is the order? Impugned order?
Order, impugned order is page 29.
Page 29.
Annexure 9.
You're aggrieved by this order?
Yes, Lordship.
Please read the order.
Lordship, today is the date fixed for written statement. Both sides are represented. The learned counsel for the defendant by petition number so and so prayed for adjournment for filing written statement. Perusal of the case record shows that the statutory period to file return statement is already over. As such, petition number so and so is rejected. Fixing on 22/12 for document lordship.
You want to stay?
Yes, lordship, I want to say. Also, kindly see the annexure 3 lordship. This is the process server report lordship. The process server.
Just a moment, just a moment. You have annexed only one order, no?
Yes, lordship.
You have
Other
to
order is
annex.
also annexed lordship.
Huh?
That is annexure 2.
See, you were present on that day. You were present on that.
Yes, lordship.
You are the defendant.
I am for the
You
defense.
have annexed only one order.
But lordship, I have.
I cannot stay. You'll have to annex or the order.
Yes,
in
lordship, I
PV
have annexed all the order. Kindly see the annexure
so
2.
that I can see your conduct.
Yes, lordship.
Where have you annexed
annexure
all the
2,
orders?
annexure 2, page number 19. That is the type copy lordship.
Annexure?
2.
Can
Page
you,
19.
can you go a bit slow? Just a moment. I'm not getting you.
Sorry, lordship, sorry.
Annexure to page number?
19.
Okay. Oh, these are the orders.
Yes, lordship. This is the type copy and original copy is page 20.
Type copy is fine. The CPC comes also. Where is the ground in the petition?
Also, specifically mentioned ground number 2.
Please read it.
2 and 3, Lord. Yes. For that the learned trial court has committed a grave error of law apparent in calculating the statutory period for filing return statement and thereby wrongly hold that the limitation period is over on 6/11/2025. But practically from the date of knowledge and appearance of the petitioner in trial court on 6/9/2024, the statutory period of 90 days would be over on 4/12/2025. It is pertinently mentioned herein that Although the process server has submitted a report dated 6/9/25.
This is not required. Process server's report is not required.
Yes. And also, second ground is, ground number 3, page 10.
Hmm.
Audit Learned Trial Court committed a mistake in holding the date 6/11/2025 as the expiry date for filing the written statement by the petitioner defendant. Under the provisions of Order 8, Rule 1 of the CPC, the normal practice of filing written statement in 30 days from the date of service of someone, and that period may be extended not later than 90 days on the ground satisfied the Honorable Court. However, the said period can be extended with cost to the maximum period of 120 days, but the Learned Trial Court totally failed to apply its minds in proper perspective, complying the provisions of Order 8 Rule 1 of CPC, and wrongly calculated the date of limitation period on 6/11/2020 for filing returns with him by the
Process was served
on the FXC notice on 4/9/2025 lawsuit.
and the order was passed on.
6/11/2025.
Where is the process server's report?
Also Annexure 3, page 21. This is the typed and translated copy, and original copy was page 22.
Okay, then we'll allow it costs. Ex parte, we'll allow it costs, but within 1 month you appear and file your written
Yes,
statement.
Lord.
So why didn't you appear before the Lok Adalat?
The matter was not settled, Lordship. I have annexed the order also, Lok Adalat.
I've seen the order.
Yes.
What is the amount,
And-
money in question, which you have allegedly not paid?
Lordship.
Have you filed a petition?
Yes, Lordship. The
Plaint, I mean, the plaint?
plain Lordship, Annexure 1, page 13. Car loan was, Lordship, 4,40,000, Lordship. And balance amounts, Lordship, 90,000 only, more or less, Lordship.
Pardon me, your name?
P. Sohoria.
P. Surya, Government Counsel for the petitioner. Two petitioners.
Two petitioners, husband, wife, and wife.
This is a loan.
Yes, Lordship. The petitioner number 2 was the
From which bank?
Union Bank, Lordship. Bank of India.
Learned counsel for the petitioners Malavika Bhattacharjee and Sri Jayanta Kumar Bodle, who have filed this application under under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, within bracket CPC for short, bracket close, full stop. The petitioner is aggrieved by the order dated 6/11/2025 passed by the learned civil judge within bracket junior division number 1, bracket close, Nagaon, in connection with money suit number 22/2022, comma, ठीक है sir, rejecting petition number 2798/2025 filed with the petitioner stroke defendant praying for adjournment of the case to file written statement, and thereby the petitioner was debarred from filing written statement, full stop. It is submitted that the petitioner will be highly prejudiced if the petitioner is not allowed to contest the proceeding and file written statement, full stop. A money suit was brought against the petitioners by the plaintiff, comma, Bank of India, for recovery of rupees 1,55,155,901,103, rupees 1,55,901,103 only, together with further interest thereon, as a derivative accrued, together with interest accrued, full stop. It is submitted that notices were issued and the petitioners have received the notice on which page?
Also, process server report was 4/9, but he came to the knowledge on 6/9/2025, lordship.
It's okay. Which
That page number, lordship, annexure 5, page 25, lordship. On the date he appeared before the learned trial court, lordship.
No. You stated that you have given the process server's report. Annexure.
Annexure 3, page 21.
Page
21.
21. Which was affixed on the petitioners, on the door of the petitioner's residence on 4/9/2025, full stop. It is submitted that the petitioners returned home on 6/9/2025, and they learned LEARNT about the notice being served upon them, full stop. The petitioners have also annexed copies of the orders in the money suit brought up by the plaintiff, registered as MS number 22/2022, full stop. The copies of the orders are marked as annexure. Which page?
Which order, lordship?
Orders?
Impugn order.
The orders, huh?
Impugn order is page.
No. Copies of the all the orders.
Page 19, type copy.
Annexure 2. of the petition, and the process server's report is at Annexure 3 of the petition. Annexure 5 is the order dated 6/9/2025, which reflects that the petitioner was present and had prayed, petitioners were present and had prayed for adjournment to submit the written statements. Full stop, the prayer of the petitioners was allowed. And as there was an element of settlement, the case was fixed for Lok Adalat on 13/9/2025, full stop. However, the matter could not be settled on Lok Adalat, and the next date was fixed on 24/9/2025, full stop. The petitioners then approached the court for another date to submit the written statement, and the next date was fixed on 6/11/2025, when the impugned order was passed rejecting the petitioner's prayer for time to file the written statement, full stop. It is submitted that the learned court has misconstrued that the statutory period to file written statement was over. Full stop. It is also submitted that the statutory period would be over on 4/12/2025 if the date of service of notice is taken into consideration, full stop. I've considered the documents submitted along with the petition, full stop. It appears that an opportunity may be afforded to the petitioners to appear to submit their written statement, full stop. In the interest of justice, this petition is allowed with cost of rupees 1,000.
I got so many causes here. They, Lordship will produce the record. It is no proof that the service was properly served on me. First of all, second thing, the court on
No,
inform.
this is not relevant now because you have already appeared, no?
No, I
Whether
appeared
proof
on
or
the
not
first day.
proof,
This is a
no.
particular one day, but thing is that it is not, but repeatedly I have failed. And
See,
somebody
whatever-
is Salembar.
okay, I won't impose cost. All right.
Okay, what means Salembar Association case is
500?
very clear.
500?
My-
Salembar
my-
Association. Salembar Association,
Yes,
yes, I understand. That
Yes,
is why on the basis of that
By the
judgment,
way,
I
by
am
the way.
allowing ex parte.
By
that's
the
it. Cost of rupees 500, full stop, subject to the condition, full stop, no comma, subject to the condition that the petitioner shall appear before the learned trial court within 1 month from.
Submit, it is already we appeared, but only you have to submit the written statement.
Shall submit the written statement within 1 month from the date of this order.
Must-
In terms of the above observation, this petition stands disposed of.
May I please, your lordship? Lordship, this application is against the rejection order of the petition which was filed under Order 7 Rule 11 for rejection of the plaint. So basically, the rejection order was based on saying that the cause of action is only a bundle of facts. But the meaning of the cause of action in the wider sense,
Your claim was rejected.
my lord,
Your plaint was rejected.
no.
Oh.
The petition filed for rejection of plaint was rejected. That is, the petition under Order 7 Rule 11 was rejected.
The petition was accepted.
No, yes,
Will issue notice that?
my lord, but for the stay, that may be stayed, my lord, because the petitioner will suffer irreparable loss. Why? I'm submitting, my lord. The claim of the plaintiff was that for compensation of the for damages of his reputation, it's a defamation suit basically. So the defamation which was he has alleged, my lord will please to find at page 23 from that letter, which was a grievance to the higher authority. The plaintiff is a bank official. So the defendant is a customer of that bank. So he wanted to renew his cash credit account. So he couldn't renew only because of the harassment of the plaintiff. That's why he wrote a letter, complaint before the higher authority that so-and-so is doing such thing. So whether that can be a defamation, my lord. That's why I'm urging before your lordship that that a suit cannot be maintained on that basis. Because suppose if I if I lodge a complaint before a police station against somebody, whether that person can come before the court
This is for
filing a
damages.
defamation part.
Defamation is criminal case. This is for damages.
Yes, it's a civil defamation here. Page 23 is the letter.
Where is the plaint?
My lord will please to find the
Page
plaint.
23 is the letter.
Yes.
এই নোটখন গুচি গ'ল নেকি ৰেকৰ্ডৰ লগত নোটবুকখন হ'ব দিয়ক ইয়াত আছে আৰু হ'ব
Plaint starts from page 13.
let us go to the letter first.
Yes, page 23, my lord. This is addressed to the General Manager, Bank of Baroda, Head Office, Alkapuri, Baroda, Gujarat.
Please read the letter.
Yes, that I'm reading. It was addressed to the General Manager, Bank of Baroda, Head Office. So, subject unwarranted delay in processing of renewal and enhancement of commitment of my cash credit account number so and so. Respected sir, in reference to the subject cited above, I would like to inform you that lately I am facing an issue with the proceedings of renewal of my cash credit account in the name of Messrs. Soros Traders, hosted in Bank of Baroda. Soros Traders, he is the proprietor. Fancy Bazaar branch. Renewal of my cash credit account, which was supposed to be renewed by 30th of March 2023, haven't been processed yet.
You're for the bank.
No,
You're
I'm the customer of the bank.
customer. Okay.
Yes.
Or the
So my cash credit account was not renewed because of the plaintiff conduct.
MS Soros Traders.
Yes, I'm the proprietor of the Messrs.
Okay.
Soros Traders.
Right, all right.
I have been repeatedly following up in person with branch, assistant manager and branch manager. Each day a new date has been provided to me to come to branch. The last interaction as of today was on 4th of March when I reached branch as the meeting been scheduled by assistant branch manager, and to my surprise received an update from branch manager that he is on leave for his marriage and there is no one at branch who can process my account proceedings till he is back. Branch manager didn't come forward to provide any help, rather he is saying to wait for another 15 days. Afraid to say, but having such interaction with the branch manager, Mr. Anand Mishra, and assistant branch manager Devapriya Deb, he is the plaintiff here, Devapriya Deb, I'm getting a fail malicious events in which they are just making me come again and again to bank to have my cash credit account renewed without any cause, whereas they have all necessary documents from me to process the request. There was also been a commitment by branch manager that during this year renewal, they will also increase my cash credit balance. However, right now, I see the very first thing which shall be done as per process on 30th March is still been pending, and I am very much susceptible if they are at all going to look into the enhancement request. I feel I have been repeatedly harassed by the assistant manager of the branch, Mr. Devapriya Dev, which leading to the case for execution of the enhancement. On the regard, I want to inform you that Government of India city so and so scheme for the development of the entrepreneur or the promotion of the business, but from your branch has expressed their inability to implement so and so in my case when requested by me several times. From the starting of my business in the operation of the branch, not a single case has been found default transaction. I couldn't understand what is the reason behind. I am taking a moment of yours, express the hardship, which,
Okay, where is the plaint?
my lord,
Plaint,
from page 13, it starts from
page 30.
13, 1-3, my lord, or 1-4.
Okay. Against this, the plaint has been
Yes,
brought up.
against this application plaint has, damages has been claimed.
Okay.
So it's
Page 1-3, no? Let's see.
1-4 basically, 1-3 is the notice,
Let's see the plaint.
1-4, my lord.
If there is any ground for stay, let's see the plaint. Okay. 1-4, yes.
It starts from 1-4, mainly paragraph 4 at page 16 may be relevant from that.
So you have claim for damages basically.
Yes, claim for damages only.
Damages for defamation.
Yes.
Where is defamation
I
described?
don't know, my lord. Where is the defamation?
Defamation is described in criminal IPC.
Yes, but not in the civil procedure. And my lord,
No, but if you have a criminal case, which usually happens,
yes,
side by side, then they claim for damages also. If you have a criminal case for defamation, side by side, they
claim for civil defamation also.
Yes,
But they
do
didn't file any criminal.
Then if they win the case, then this is a good case for filing the plaint.
Yes, yes.
But now I don't know.
But there is no ground in the plaint.
Let's see.
Paragraph 4. That the defendant is the proprietor of a proprietary firm by the name and style of Messrs. Soros Traders, and said proprietary entity maintains banking relationship with the Bank of Baroda and or the employer of the plaintiff. The defendant's proprietary concerns banking needs are serviced by the Fancy Bazaar branch of Bank of Baroda. That amongst others, the defendant also has a cash credit account in the name of his proprietary concern, and same was also being serviced in the Fancy Bazaar branch, that is the branch wherein the plaintiff is serving as the senior manager. That the plaintiff states that the defendant keeps visiting the workplace of the plaintiff for various reasons and for his own banking related work, and as such he is acquainted with the plaintiff, and the plaintiff maintains a healthy working relationship with the permissible limits of the working ethics with the defendant. That the plaintiff states that on 4/5/2023, when the plaintiff was on leave due to his own wedding schedule, on 6/5/2023, defendant without any rhyme and reason on the same day, that is on 4/5/2023, filed a complaint before the general manager. That is the complaint manager. Bank of Baroda, Alkapuri, so and so, inter alia, with the allegations that cash credit account of the proprietary concern of the defendant has not been enhanced, renewed after the end of the financial year on 31st of March.
It's okay, it's okay. So he must suffer from some mental agony, something. He must suffer from some mental.
Maybe, but where is the ingredient of defamation, my lord? There must be some ingredient of defamation. It should be published to the third person, but there is no publication.
Where's the order? Let me see.
My lord, it's basically the operative part at page 81.
No, you have to go through the order. You're asking for stay, no?
From page 77.
How many pages?
It's 77 to 83.
You sit down and I'll read it. You sit
My
down.
lord, my lord.
You see, if you keep on harping at the word defamation, then maybe there's no case. But if you're claiming for damages for filing a frivolous complaint, then there is a case.
Might be, but if your lordship have a look at the plane, what is the prayer basically?
Just a moment, I'll complete reading this order.
But that also cannot be, because the complaint is written to the superior authority, ventilating his grievances that his cash credit account was not renewed, so and so, so and so. But if it caused mental agony also, that person, whether he can prosecute this person, my humble submission is no.
Filing false complaint.
Filing malicious prosecution is a different, it's a
No, not
criminal,
malicious
false
prosecution.
complaint even.
This is not prosecution at all. This is a complaint before the manager.
Yes, yes.
Not before any court. So it's not malicious prosecution also.
Exactly.
So why are you not allowing to extend his cash credit account? Why are you not allowing? What is your problem?
No.
He wants to extend his cash credit account. So
I
why
have,
are you not allowing?
I have submitted all the required documents before 1st of March 2023. I don't know. That's why he wrote this letter. So there might be some malicious event. That's why he used that word. Oh, they come up with that there is a defamation. How? I don't understand, my lord.
You are a bank employee.
No, I'm the customer of the bank.
Customer, you are the customer.
So
So your account is not being
renewed.
renewed.
It's a cash credit account basically. So like OD account.
So then you have filed a complaint
Yes.
and he is not allowing.
Yes,
He is not allowing.
He is
Your
not allowing.
opposite party is not.
yes, yes.
Please sit down.
My lord, no.
Please, plaint is at page 14, no?
Yes, my lord. Starts from.
He is claiming damages of 50 lakhs.
Yes. It's an absurd claim, basically. So I wrote a letter ventilating my grievances, and the learned trial court has rejected on the ground that opined that the cause of action is only a bundle of facts. But under Order 7, Rule 11, the meaning of cause of action is very wide. So it is basically the maintenance of the suit. And it's
Where
not the
are the
infraction of the right, it's infraction coupled with the right itself.
No, it's okay. We'll not go to the criminal definition of defamation.
No, my lord.
Where are your grounds?
My lord, at page, it starts from 6.
See, you are going to the criminal definition of defamation.
Even civil defamation also, the same thing, my lord.
No? We'll issue
Suppose,
notice.
what is
We'll issue notice.
my lord, what is the ingredient of defamation, my lord?
It's okay. We'll grant you stay. Let us issue notice here, both sides. We'll dispose it off on admission or we'll grant stay. After hearing both sides.
Okay. My lord is staying the matter, right?
No,
My lord, otherwise it will be a futile exercise, my lord.
no, I'm not staying.
Because now it has been fixed for evidence. So we'll have to file evidences and all. So thereafter, if you're not,
You can take adjournment. I'll Bring it on record. You can take adjournment.
My lord, prima facie, there is no case, basically in the plaint.
Maybe.
My lord,
I'm saying.
if there is, if there is a maybe, my lord, so, then the question of stay will arise, my lord.
And that's why I'm giving you my word. After hearing that side, maybe there are some grounds, or I feel there are some grounds to stay, but we'll hear the other side. We'll not go to the
My lord,
definition of the.
my lord knows it. It will go longer and longer, then they will take time, they will get, take the adjournment.
In paragraph 6, all the criminal elements.
No, my lord, may take the other thing, my lord.
No, we'll issue notice. I'll bring it on record. You take adjournment. You don't submit your evidence. Don't submit your evidence. But we'll hear the other side and then we will stay.
My lord, may hear the other
There-
side.
there
Definitely,
appears
my
to be
lord,
grounds
they
to
have to
stay.
hear the other side. But
There appears to be some grounds to stay, but have to hear them. I'll bring it on record.
My lord,
You don't submit your evidence. Issues have been framed.
lordship have candidly admitted that there are grounds for
No,
stay.
issues
So,
have been framed. Na? Issues have been framed.
issues have been framed.
So I'll bring it on record. We will call them. We'll call them.
My lord. But
I do not want the trial court records. I only want the person to place his submission.
my lord, I understand. But he will take the adjournment again and again, my lord.
No,
My lord knows
but
the.
only one date. Only one date. You see, low and steady wins the race.
Okay, my lord.
Only one day. It's no good to jump. Let learned counsel Mr. B.M. Deka is present for the petitioner, whose steps to be taken to issue notice to the respondent. One respondent, no?
One respondent.
Respondent, returnable within 2-3 weeks.
2 weeks.
Returnable within 2 weeks. Full stop. The submission of interim stay will be considered on the returnable day. The petitioner may also pray for adjournment before the learned trial court on the next date fixed. Please, we won't call for records. Not required. You have given.
Already all records are
The
here.
main order is here.
Plaint is here, order is here.
Plaint is here, so okay. List the matter after 2 weeks.
That may be fixed, my lord.
Okay, list the 2 weeks of the data reduction. Will they come after 2 weeks? How far is he?
It will not be
staying?
listed otherwise. It will not be listed.
11th of February. Okay.
Much obliged, my lord.
May it please, your lordship. Lordship, here we are the defendant. The plaintiff has filed a suit against us under Urban Area Rent Control Act for our eviction and area rent. Now, during the pendency.
Item number 5.
Item number 5.
Are you ready with the admission? Both sides are ready? Okay, we'll take up the hearing then.
So they have filed a suit for recovery of area rent and my eviction. So in the during the pendency, they filed a petition stating that during the pendency, I have deposited certain amount in the plaintiff's account through check. So during the pendency, the plaintiff files a petition stating that this check amount which has been deposited by me to declare that as illegal transaction. So that petition was allowed by the court below, stating that the said amount is illegal, which is very amusing, I must say. And
So, yeah, where is you are agreed by which order?
Agreed by the order dated 16/11/22.
Order dated pay.
The last page, your lordship will find
Page number-
76.
76.
Yes. Very short order.
Please read the order.
Yes, both sides are represented. Today, the date is fixed for passing order on petition number so and so. By this petition, plaintiff submitted that this suit is filed for ejectment due to bona fide requirement and for recovery of rents, as the defendant is a defaulter. But instead of tendering the rent to the plaintiff, the defendant, without any knowledge and consent of the plaintiff, deposited rupees 52,800 in the bank account of the plaintiff stealthily, being the bank account number so and so of SBI Dibrugarh branch, by check number so and so. dated so and so, account number so and so, Vijaya Bank, Dibrugarh. Therefore, the plaintiff by the petition prayer to declare the money which has been transferred by the defendant without his consent to be illegal and direct the defendant to take back the money. Third perils, the court shall, in order to decide this aspect of non-payment of rent by the defendant as alleged by the plaintiff, taking into account the status as on the date of filing of the suit. The subsequent, this is the finding, the subsequent transfer made of arrear rent is only a matter of compromise between the parties. But in the present case, I do not see any chance of compromise. Therefore, the money transferred without the consent of the plaintiff is declared to be illegal. As such, the plaintiff is at the liberty to either retain or transfer back the amount to me. So this was the impugn order.
So
Now-
what is wrong in the order?
Your Lordship, first of all, how can it be illegal? Because the money which was transferred without the consent, they're saying. This, it has been transferred in the bank account number, so and so 1102, so and so 7105. Now, this bank account pertains to this, the landlord, the plaintiff. So how can it be illegal? Because this particular check is of the year 2020. This is one of the payments which I have made. And similarly, I have been making payments since 2014. And that too without any objection from the plaintiff. Now he has accepted all the payment. He has not, he has retained that, he has used that. Now they have admitted it in the cross-examination.
Have you submitted receipts?
Yes. Annexed all that.
You have been making payments since
Since
2014
2014.
and they have been receiving it.
Yes, without any objection.
Only in 2020 they have raised objection.
2020, they have raised objection. Now the receipts, your Lordship will come to page 19 onwards. Twen- 21, that will be the check. That is dated 9/12/2014. So the period for which the amount has been transferred is June 2014 to May 2016, your Lordship will find. So thereafter,
From page
again,
19 onwards.
from June 2014 to May 2016, this first check.
From June, when was this case filed?
The case was filed in the year 2015. 15.
From June 2014 till May 2016.
16, yes.
Case
Thereafter,
filed in the year 2015.
2015, yes. Precisely, the date will be 21/9/2015.
Okay.
Then the next receipt, your Lordship will come to page number 32. That is the second check. Now there your Lordship will find rupees so and so, check dated 10/5/2017, and the period from which I have been making the payment, June 2017 to May 2020. He has been receiving all throughout. Now,
You have paid advance.
Not advance.
together for, yes, 3 years we have been paying.
The check was paid in,
2017.
2017.
so that will be advance only, they are paying.
No, Lordship, the eviction suit was filed in the year 2015. And as per the provisions,
See, no.
yes,
This check was, the check is dated 2017.
exactly, Lordship.
10/5/2017.
Exactly.
And this check was for the rent of 2017 to May 2020.
Advance rent.
Advance rent, that's what
Exactly.
I'm saying.
4 years together. Now thereafter,
First of all, they have to explain the position of default. Then only they can.
position of default will come in the title suit. Now, this is not the thing which is to be decided by this court.
No, but why, what, if it is declared illegal, why
No, no, no.
in midway
How-
you have come before with a petition?
No, no,
can
because it
tell
has
me
been
no.
wrongly declared illegal. So how can it be declared illegal? Very absurd.
No, it
Because-
will, no, you see, I'll reject it. It will be like deciding the case, whether these checks are illegal or not illegal now.
Yes.
It will be like taking up an appeal, not a revision petition. I will reject it.
Then your lordship may share my senior ones. Because this is outright illegal, because the.
No.
I'll take your
But
lordship.
your senior will say the same thing.
Okay, then I'll take your lordship to the evidence.
See. It will
Because
be
this is a
deciding an appeal now.
This is not appeal.
Now I'll not go to the evidence.
No, once your lordship they come to the order passed by this honorable court also, 10/4/2023. What has the court said here? (10/4/2023).
See, now I cannot differ with the same court.
Yes.
One court has
No,
passed.
just I'm showing the view, your lordship. The second last.
Because it is before the same court only.
How it
How can they, now I
Exactly.
do not want to admit it, then how? can I-
But illegal, this is very wrong. How can it be illegal?
Lordship, as per the
Let-
provision
show
of
that
the
it's
urban.
illegal.
It's better you
Yes,
don't
let-
send me the order dated 10/4/2023.
Exactly.
How can I differ same bench? And but I'm not agreeing with it.
Your lordship may hear the other side. Whether you can
No.
show that.
I won't hear the other side.
This is nothing but delaying the process, Lordship.
How
The
they
eviction
delaying
suit, the
process?
stay is
They
there
are
and
delaying it.
the stay is there and they are enjoying the stay.
Obviously, this is not a case of declaring the transaction as illegal.
No.
They will get back the
Yes,
money.
yeah.
Now, why should
This
we
will-
give? This is not a
will-
case of default
this will
event.
bear Final order. If I pass any order now, it will have a bearing on the
Exactly,
final
Lordship,
order.
exactly.
You defer it. Defer this case, huh? I'm not going to hear the other side. I've already made up my mind. Parties are represented. List this matter after 2 weeks. The interim order shall remain in force till the next.
Lordship, kindly fix a date because this matter is
Yes,
lingering for a long period of 2015 matter. Now it is 2026. This
No,
person
not
is in.
15, 2023. The CRP was filed in the year 20.
I'm not saying about the CRP, I'm saying about the main suit, 2015 suit, eviction
We don't need to
suit.
talk about the CRP
This is
here.
the eviction suit, this for last 10 years, this tenant is
Why
in
they're
possession
going
of
to
the
court
property.
here?
You know how tenants. are.
Exactly, Lordship, exactly. This is the
Will
thing.
they vacate? They'll go up to Supreme Court.
Exactly. I'm not, I'm not on that, Lordship, but I'm submitting the, kindly fix a date, Lordship.
Okay, 2 weeks of data deduction. 9 February?
9 Feb.
Release this matter on 9 February.
And this cannot be a ground for deferring the matter. One court has passed an order showing that particular thing. This is not a good practice for me.
I can refer it. Who has stopped me from doing it?
You see, that order I have not seen.
Exactly.
Maybe that order is valid order. I have not seen. I won't go also to that order. Because it's the same coordinate bench. I have not gone through the order.
Obliged, your lordship.
May I please, item 6, ma'am.
Oh.
May I
If you're
please,
ready, then you can submit. Admission, these are all admission matters.
yes, ma'am. So impugn order, your lordship will find that page, my lord. 53, madam.
Yes, I'll come back after 5 minutes, Mati Jackson. I'll come back after 5 minutes and hear you.
Madam.
Both are ready, but they're hearing, so I'll come back after 5 minutes and hear you. Bell to Mary.
One number, right? 6. Time lo bosega, no? Hearing nige.
Let's start.
May I please, your lord? Well, the respondent as plaintiff, my lord, had instituted a party suit, my lord, for declaration, eviction, recovery of caste possession before the Munship number 1, Tinsukia, my lord. Well, in that case, my lord, after my lord issues were framed and
at the stage of, my lord, evidence, my lord,
Hmm.
on 19/12/2022, which your lordship will find at Annexer 3, my lord, page 38, my lord.
Hmm.
My lord, the plaintiff, my lord,
Hmm.
filed his, my lord, evidence on affidavit of the PW1, my lord, which is
Page
the plaintiff,
38. Page 38?
my lord, which is the plaintiff, my lord. He filed his evidence on affidavit, my lord,
Page 38?
page 38, my lord, Annexer 3, my lord.
Okay. Yes.
And prayed for time, my lord, to file further plaintiff evidence, my lord.
Hmm.
Then on the next date, my lord,
Annexure 3, no? Hmm.
Annexer 3, my lord. On the next date, my lord, he filed a petition, my lord,
Hmm.
under the, my lord, trial court and first appellate subordinate court case management rule 2007,
Hmm.
praying for, my lord, allowing the cross-examination of the PW1 before, my lord, submission of the evidence of the other witnesses, my lord. Praying to allow the, my lord, cross-examination of the PW1, my lord, the plaintiff, before, my lord, his submission of the evidence of the other witnesses, my lord,
Hmm.
which was, my lord, subsequently allowed by the trial court, my lord, against which, my lord,
Hmm.
my lord, we are before the Honorable High Court, my lord. The Honorable High Court had allowed, my lord, stay of the impugned order, my lord, which your lordship will find
Where
it
where
page.
is the order allowing?
Order,
the-
your lordship will find it Annexer 7, my lord.
No, no.
Impugned order, my lord.
Impugned order, yes.
My lord.
Annexure
Impugned
7.
order, your lordship will find it Annexer 7, page 53, my lord. Type copy, my lord.
Hmm. Okay, Annexure 7. Hmm.
Page 53, my lord. 21/6/2021. Both parties are represented. I have heard the plaintiff side. Defendant side, although present, did not make his submission, my lord. But we had, my lord, submitted our written objection, my lord. Plaintiff side, white petition number so and so, prayed for cross-examination of PW1, then to file evidence of other witnesses. But defendant side raised objections stating that law does not bar plaintiff from adducing evidence altogether and get cross-examination done. I have considered the submission made by the plaintiff side as well as petition and objection of parties. Law does not bar plaintiff from cross-examination of PW1 first and to submit other evidence later, my lord. Hence, prayer of plaintiff is allowed, my lord. Against which, my lord, we have prepared this, my lord, revision petition, my lord. Now, your lordship will kindly go through the, my lord, trial court and first appellate subordinate courts rules, my lord, which your lordship will find at Annexer 6, my lord.
Page?
Page, my lord, it starts from page 43, my lord. Relevant portion your lordship will find at page 47, my lord. Last paragraph, my lord. If the parties are not keen about settlement, your lordship will found, my lord. Last paragraph, my lord.
Page 47.
Page 47, starts from 43, my lord. Relevant portion your lordship is at page 47, my lord.
Okay. Hmm.
Last paragraph, my lord.
Hmm.
If the parties are not keen about settlement, the court shall frame the issues and direct the plaintiff to start examining his witnesses. The procedure of each witness filing his examination in chief and being examining cross or re-examination will continue one after the other. After completion of evidence on the plaintiff side, the defendant shall lead evidence likewise, witness after witness. Here, my lord,
Hmm.
the process that, my lord, examination of chief of being examined in cross-examination, my lord, will continue one after another, my lord. It has been, my lord, represented that evidence shall be filed, my lord. One witness will appear, he will file his evidence, my lord. Then he will be cross-examination or cross-examined. Then, my lord, witness number 2 will file his evidence and then he will be cross-examined. Which is, my lord, not the procedure of the court, my lord. This is a humble submission, my lord. Because it will create a, my lord, undue advantage on the plaintiff, my lord, because he will get to know the line of defense of the my lord, defendant,
But
my
you are
lord.
the plaintiff, no?
My lord.
You are the plaintiff, no?
No, my lord. I am the
defendant.
I am the defendant in the title suit, my lord. If, my lord, cross-examination of the plaintiff is allowed, my lord, before, my lord, his filing of the evidence in
Yes,
affidavit of the other
You can
witnesses,
fill
my
out
lord.
that too now, yes.
My lord, that will, my lord, create undue advantage to him, my lord. Against which we have come before your lordship, my lord, and Honorable High Court has stayed the operation of the impugn order, my lord. Grounds, my lord, as per my lord, section 138 of the, which is clearly states, my lord, the order of examination of witness, 138 of the Evidence Act, my lord.
Evidence account, sir. You are the defendant petitioner.
My lord, I am the defendant petitioner, my lord.
138 evidence act.
138 of Evidence Act, my lord. Order of examination, my lord. Witnesses shall be first examined in chief, then cross-examined, then re-examined, my lord. So all the witnesses are first to be presented and examination, evidence on affidavit are to be submitted by. Only then, my lord, the cross-examination will be taken up, my lord.
Okay. Yes.
Yes.
Anything else?
No, my lord.
The learned trial court has rightly passed the order, your lordship, and that law is clear in this case. There is 47 that your lordship has perused. If the parties are not keen about settlement, the settlement was, mediation was sent, but it was not settled, then it is remanded back. The court shall frame issues that directly. The procedure of each witness filing his examination chief and being examined in cross, then means one file, then examine in cross. Or re-examination will continue, one after another. It is clear that we can, as per law, the learned trial court has rightly passed order.
Correct.
Rightly passed order. There is no irregularities in the learned trial court.
Pass according to the rules.
That is the rules. There is no irregularities.
138, it's not in accordance with 138.
But as per this.
My lord, if evidence are not
Rules
submitted.
cannot surpass the.
That's so. But this.
This is
CPC.
This is CPC.
CPC.
Civil rules.
Civil rules. And that is said possible. Guwahati High Court case management rules, as per this in frame issues and then settlement, it is possible. So it is, the learned trial court has not found irregularities. There is no
This
irregularity.
petition is filed under which section?
My lord, under 227 reduced, my lord. Reduced, my lord,
115.
115 months.
So you are directed to cross-examine.
Yeah,
the
my lord.
witnesses.
I am directed to cross-examine the plaintiff, my lord. Before, my lord, submission of the evidence on affidavit of the other witnesses, my lord.
But there is no irregularities. I am not found irregularities in the order of the learned trial court. There is no irregularities in the order of the learned trial court. Because rightly passed order, your lordship.
My lord, there is misrepresentation of the, my lord, rules, my lord.
No.
One after the another, yes, my lord. It has to continue one after the another. But
it's
after
clear.
submission of the evidence on affidavit of all the witnesses, my lord.
No.
If evidence on affidavit of all the witnesses are not submitted, my lord, then, my lord, cross-examination of PW1 will lead to, my lord, undue advantage to him, my lord.
Obviously.
But law is clear. Law is
No, this is not law, this is rule.
rules here. Rules. High Court management rules here, this is clear. This exists, it is not amended or.
Case management rules,
Right.
you see, we have the High Court rules and orders of civil rules and orders. This is different, but this is case management rules. Do you have the civil rules and orders of the lower courts?
In petition on page 39, trial court, It is filed under that rule, Your Lordship, 2007 High Court Management Rule,
Okay.
page 39.
Oh, it was filed under.
That,
You have filed.
that's where, plaintiff side filed, page 39. Is
Then
clear
there is
that-
no bar in the rules.
Lordship, there is no bar.
My lord, even in CPC, my lord, your lordship that we submit, my lord.
CPC. But you see that petition was filed under the.
Yes, my lord, petition was filed under the High Court and subordinate trial management rules, my lord. But the interpretation of my humble submission is, my lord, interpretation of the rules, my lord, one after the another, my lord.
Will, I think we'll have to hear elaborately. We'll admit it. Hmm?
Yes,
We'll
lordship,
admit
very
it.
well.
We'll
Trial
admit
court
it and
record,
hear it. It's important. We'll have to hear it. Stay was also granted, no?
stay is also granted.
So that
Fix a date after.
I think that we'll need an elaborate hearing on the rules.
Rules.
Then
Which
CPC.
law is applicable?
Evidence Act.
Which law is applicable?
Yes, yes. Then, so we'll admit it.
You can fix the last week of February. Your Lordship.
And you see, he has a point. Because
Yes.
it's very obvious. Once you will start, he will start cross-examining, then you will get to know where you will have to.
Yes, my lord, they will fill up his lacuna. my
It is
lord.
correct,
Yes,
correct,
yes.
but law,
My
as
lord.
per rule, it is also not, petition also correct.
All the error you will
Right.
be able to correct. And it will be difficult for him. His case won't survive them. You'll get to know his line of defense and then. Third learned counsel, Mr.
Yes, for us, sir.
As per us, sir, for the petitioner. This case is, this is a title suit, no?
Title suit.
For the petitioner, who was the plaintiff, who brought up the title suit number TS 121/2021
My lord.
against the defendants.
The petitioner is the defendant.
Hmm?
Petitioner is the defendant. I think so.
Okay.
I am the defendant in the title suit.
Third learned counsel, Mr. S. Parashar, for the petitioners,
Petitioners, my lord.
full stop, and full stop, comma, and learned counsel, Mr. S. Islam, for the respondents,
Respondent.
full stop. The respondents were originally the plaintiffs who have brought up the title suit number 121/2021 against the present petitioners, full stop. It is submitted by order dated
21/6/2023.
21/6/2023, page.
Page number
It's
53.
53 years. 53.
53 is the type copy, my lord.
53.
Annex.
Annexure 7, my lord.
(21/6/2023), the defendants were allowed to cross-examine the petitioner despite the fact that the petitioners have prayed for time to adduce additional evidence.
My lord.
It is further submitted that the petitioners have not completed submitting the evidence in affidavit, full stop. Before submission of the evidence through affidavit, if the defense is petitioner plaintiff. Last sentence paper পঢ়ি দিয়কচোন। বহি এইটো নালাগে লাষ্ট সেন্টেন্সটো। Petitioners, the plaintiffs, plaintiffs. তাৰপিছত petitioner আকৌ plaintiff লিখক a petitioner plaintiffs evidence in affidavit বাকিখিনি কাটি দিয়কচোন of all the witnesses full stop before submission of the evidence in affidavit of all the witnesses if the defense is allowed to cross-examine the witnesses, the defense stroke defendants would be able to fill in lacuna LACUNAE to the prejudice of the plaintiffs, full stop. It is submitted that as per section 138 of the Indian Evidence Act 1872, the first party is to adduce the evidence and thereafter cross-examination is to commence. Whereas in the instant case, the court has allowed the defendants to cross-examine the petitioner, the plaintiff, the plaintiff's witnesses. The defense, this will reveal disclose reveal this will disclose the defense this will disclose the defense this will disclose this will allow the defendants to fill up lacuna full stop. On the contrary, the learned counsel for the learned counsel for the defendants
Respondent.
stroke respondents has
Respondent of the
has-
plaintiff, not
Huh?
defendant. I'm for respondent plaintiff.
respondent
In
plaintiff.
the respondent, in that plaintiff.
Or this will reveal disclose এইটো কাটি আছো this will disclose the নাই মই কৈ দিছো মিলাব দিগদাৰ হ'ব this will disclose the নাই পঢ়িব নালাগে বহক this will disclose লিখিছিলে ন নাই এলাও কৰা নাই disclose কৈছিলো ন disclose টো লিখিবলৈ দিছিলো মই কাটিব দিয়া নাই reveal নহয় reveal টো কাটি পেলাই disclose this will disclose the defense বাকিখিনি কাটি দিওঁ this will disclose the defense of the defendants. This will disclose the defense of the defendants and will accord an opportunity to the petitioners to fill up lacuna. On the contrary, next paragraph, on the contrary, the learned counsel for the defendants has submitted that the order has been rightly, the impugned order has been rightly passed, full stop. There is indeed no bar to cross-examine the plaintiff's witness before submission of the evidence in affidavit of all the witnesses, all the listed witnesses, full stop. Next paragraph. I have considered the submissions at the bar with circumspection, full stop. It appears that I find force in the argument of the learned counsel for the petitioners, full stop, thereby this petition is admitted for hearing. List this matter for hearing. This petition is listed for hearing. Admitted for hearing now. This petition is listed for final hearing on. This petition is admitted and listed for final hearing
Last week of
on-
February, because it stays there.
on after 2 weeks.
Fix it.
On data DDO part. Which week? Last week, first week,
Last week. we
last
did it
week,
here.
last week, okay? Last week we
Right.
did data, 26 to. কল কৰা আছে নেকি আকৌ? LCR এইবোৰ কেইটা LCR নালাগে। দৰকাৰ নাই। গুচি গ'ল নেকি? You want the LCR? I don't think LCR is required. Huh?
Not required.
I don't think it is required.
Not required.
Mm.
Because petition also annexed and that rule also.
Mhm. Not required.
May I please your lordship? My lord, this appeal we have filed for slight modification of the award passed by the Railway Claims Tribunal, Guwahati Branch. My lord, the husband of the appellant number 1 died in accident, the railway accident. They filed a claim
Statutory
petition.
appeal will admit it.
No, my
We'll
lord,
admit it.
little, I have to submit.
I'll admit it, where is the problem?
No, my lord, problem is there. I am submitting, my lord, little more. My lord, 8 lakhs have been awarded. That's compensation. But out of the 8 lakhs, only 1 lakh has been allowed to withdraw. So, my lord, affiliate, they cannot survive by this amount. So, they have filed this appeal, my lord, for slight modification. I mean, my lord, for
Okay, okay.
some
The
amount.
parcel order will allow him to withdraw the entire amount.
My lord, my lord, our high courts, some orders we have annexed. Kindly see annexer 2, 3 and 4. Similar case, already our high court has passed orders modifying the award. So similar case, my lord, we prefer similar order.
Okay, we'll pass an order.
Yes, my lord.
Only, where is the order judgment of the railway tribunal?
Yes, my lord, your lordship will find
Page,
the
page.
operative portion at page 18, your lordship will find. Operative portion.
This nowadays, you have to pay 8 lakhs, no? Earlier it was 5 lakhs.
They have already deposited. the
Now
amount,
8 lakhs.
My lord,
And they won't have any objection.
but yes, my lord, similar order we prefer.
Why only 1 lakh of allowed to withdraw
only-
his children? Minor children?
Minor, the school going child is there.
No, we'll fix some amount for the minor
No,
children.
in his name, some amount may be paid. We agree with your lordship, my lord. But only 1 lakh has been allowed. Out of 8 lakhs, it amounts to denial of the compensation. my lord.
Yes, correct.
So, my lord, some amount may be allowed to withdraw so
Page
that they
number?
can, appellant can survive.
Page number?
Page number, my lord, 18, operative portion order, your lordship will find. A, subpara 2A, your lordship will find only 1 lakh has been allowed. Out of 8 lakh.
Okay.
Subpara 2A, close A, your lordship will find only 1 lakh has been allowed to withdraw and the whole 7 lakhs have been fixed deposit. So, school going child is there. My lord, 13 years. Appellant number 2, son of the deceased. He's only 13 years, school going, my lord. His education requires expenses. If, my lord, he cannot continue his education, then, my lord, after attaining majority, he will get the whole amount of what he will do by that. If he fails to continue education, that's why, my lord, annexer 235, our high court's order, similar case, by modification, some more amounts are allowed to withdraw. So similar order may be passed. We should not be discriminated, my lord. And LCR not necessary, my lord, in this case. They have already deposited.
No, I'm not asking for LC.
Yes.
Yes, my lord. It is, my lord, your lordship will understand, it is our money. We may be allowed to withdraw some amount.
How much you want to withdraw?
My lord, how much? Another, my lord, 1 lakh has been allowed to withdraw.
Yes.
We want to withdraw another 3 lakh. And 5 lakhs in the name of the
Children.
minor son. Maybe there.
No, out of 8 lakhs.
Yes.
4 lakhs. 4 lakhs, my lord.
4 lakhs.
4 lakhs may be allowed.
To withdraw. And then
Two.
2 lakhs is in the name of.
Your 2 lakhs is maybe deposit.
2 lakhs each.
Is. My lord.
Okay.
My lord, actually, mother.
How many children you have?
My lord, one side.
Only one side.
Only one side. My lord, the mother is matured. She can understand how her money should be used in the interest of the family and for the education of her child. So, my lord, our humble submission, there may be some amount fixed deposit in the name of minor child. The other amount may be allowed to do. 6 lakhs.
How old is the son?
My lord,
How old is the son?
son is 13 years.
13 years.
Yes. He's still going.
Hmm.
So, my lord, his education is concerned.
Hmm.
So, let there be 2 lakhs, my lord, fixed deposit in the name of the minor child. And the other
No,
amount may be
no.
allowed to. They have no objection.
No.
They have already
Okay.
paid. They have nothing to say.
No, you see.
As per the rule, you're
My-
fixed.
Yes, my lord,
Not a
rule,
fixed.
my lord, kindly see, they are submitting on the basis of rule. Lordship, kindly
That
see.
rule is 2017 rule, no?
Yes, my lord,
Some
no.
railway account.
my lord, it is my lord, Railway Claims Tribunal Procedure Rules 1989.
No. Now the new rules is 2017.
Yes, my lord, I am showing it. I am showing it, my lord. It is the rule, the Railway Accidents and Untoward Incidents Compensation Rules 1990. And
No,
Rule
no.
5,
No.
Lordship, Rule 5.41.
You see the amount, no?
Yes, mode of payment, my lord.
Let me see.
Mode of payment. It is here.
Railway?
My lord, Railway Accidents and Untoward Incidents Compensation Rule 1990. It is regarding
Rule
mode of payment.
5.
Yes, Rule 5. Rule 5.41. my lord.
Ask. Kita
We have given the
page number given.
underline. Your lordship will see.
এটা পেজ হ'ব নে 49 এখন পুৰণা কিতাপ নেকি
Rule 4 is there.
2023 2022 এখন নতুন
My lord, that rule says, that rule, my lord, clearly says, at the time of passing the award,
একেখন বুক হয় নে কিমান আছিলে ৰুলটো ৰুল 541
Rule 541, yes, my lord. At the time of passing the award, my lord, claimants should be examined regarding their financial condition, needs of the claimant should be examined. But unfortunately, tribunal has not considered this provision.
It's okay.
Straight away, the whole amount has been fixed. How they will survive, my lord? That's why, my lord, in the same line, my lord, already our High Court has passed several orders, series of orders. We have annexed only 3. Your lordship will see. And we pray for similar order. Your lordship will find the similar order at page, my lord, at page 21, annexure 2. We pray for similar order, my lord, as the case is similar. This order has been passed by our High Court, Honorable Mr. Justice Parthajyoti Saikia. Next order, annexure 3, at page 24. And the third one, my lord, at annexure 4, page 27. 3 orders we have in it.
You see, there
Same line.
Stabilo has paid rupees 2,40,000 to the sons.
My lord.
Not only 2 lakhs.
Yes. So, my lord, appellants should not be discriminated. They should be allowed to use
See,
their
your
money properly.
2,40,000 has been paid.
Yes.
Case number, appeal number, MFA 83 2023, 2,40,000 has been paid. Then MFA, okay, here 2 lakhs has been paid. MFA 52 of 2023, here again, okay, because 2 sons, so 2 lakhs have been paid. So we'll keep 3 lakhs, not 4 lakhs, 3 lakhs for the son.
My lord, yes, your lordship.
How old is the son?
30.
13 years,
13 years.
13 years.
See, he'll attain majority after 5 years. Then it
Yes.
will be helpful. That
Yes.
4 lakhs will become 7 lakhs.
Yes.
It will be helpful for him.
As your lordship.
Mm.
3 lakhs may be there fixed in the name of the site.
Third learned counsel, Mr. A.
J. Mullah.
J. Mullah for the petitioner,
Appellants.
for the appellants. Mormi Talukdar and Krish Talukdar. Full stop. Third Miss
R. Devi.
R. Devi.
Devi.
Huh?
Devi.
R. Devi.
Devi.
R. Devi.
CGC.
CGC, you know? Oh, yes, yes. Sorry. Third Miss R. Devi, learner CGC for the railways.
Railway, yes.
For the railways. The appellant is agreed by the judgment and order dated 27/9/2024, passed in to page 2. Which page?
Page 9, page 9. Page 9 man.
এইটো হেৰি কিবা কিবি লিখিব লাগিব ন past in so and so case. Page 9 ত আছে, huh? Past in so and so case. Full stop. By the order dated 27/9/2024, the Railway Claims Tribunal has directed the respondent to pay a compensation of rupees 8 lakhs to the appellants with pendente lite interest at the rate of rupees 6% per annum from the date of registration of the application. Full stop. The appellants are agreed by the order as the appellant Srimati Morami Talukdar was allowed to withdraw only rupees 1 lakh out of rupees 8 lakhs with interest component, whereas the tribunal had directed transfer of the remaining amount into her bank account to be kept as fixed deposit for partly for certain period as follows: rupees 3 lakhs to be invested in line FDR.
Let's say, I will be allowed to.
Yes,
go
yes.
there. Port number 1. That's
Yes, yes, sure. FDRs of rupees 50,000 each for a period of 1 to 6 years in ascending order. Next line, 1 FDR for 1 year, comma, next line, second FDR for 2 years, and third FDR for 3 years in a nationalized bank. Full stop. The remaining rupees 4 lakhs was directed to be, next line, rupees 4 lakhs was directed to be invested in the name of the appellant, Sri Krish Talukdar, within bracket represented by his mother, bracket close, in a nationalized bank as fixed deposit till the minor attains majority. Full stop. It is submitted that the appellant is facing the appellant is under financial constraints. Full stop. Rupees 1 lakh which was allowed to be withdrawn will not be sufficient to meet her to meet the requirement or to bring up her child and to maintain him and raise him and educate him. Full stop. Maintain him, raise him and educate him. Full stop. Due to the inflation, due to the prevailing rate of inflation, the appellant will be unable to meet even her daily expenses. Full stop. The learned counsel for the appellant has also relied on the decision of this court in connection with Sabya Kolita and another versus UOI in case number MFA 52 of 2023, wherein by order dated 26/7/2023, the appeal was partly allowed by modifying the impugned judgment and order of the tribunal and allowing directing the tribunal to deposit only rupees 2 lakhs as fixed deposit for or 2 lakhs as fixed deposit. Full stop. The appellant has also relied on the decision of this court in Madhumati versus UOI, wherein by the order dated 10/3/2023, the tribunal was directed to pay the entire compensation of rupees 8 lakhs, pay a compensation of rupees 6 lakhs and to deposit rupees 2 lakhs as fixed deposit. Full stop. I have considered the submissions at the bar with circumspection. Full stop. In view of the foregoing discussions, it appears that the appellant will indeed be highly prejudiced if she is allowed to withdraw only rupees 1 lakhs. Thereby, the judgment and order dated 27/9/2024 in so-and-so case is hereby modified, and the appellant, and out of the amount of rupees 8 lakhs deposited by the tribunal, the appellant is allowed to withdraw an amount of rupees 5 lakhs, and the remaining amount of rupees 3 lakhs is to be invested as fixed deposit in favor of the minor Sri Krish Talukdar till he attains majority. In terms of the above observation, this appeal stands disposed of.
Masood.
Okay.
Lordship, in this matter, service is not complete yet. Okay.
I think Darakulla was here for the other side.
No, Lordship, he is for the petition.
Oh, he's for the petition, okay. Service report and service
Sole respondent.
report on respondent or respondent?
Sole respondent, Lordship.
Service report and respondent is awaited. List this matter.
Lordship, can be 3rd week of February, Lordship.
After 3 weeks.
Yes, Lordship. Date may be fixed, Lordship.
Okay, list this matter. 3rd week of February, date of the option.
Obliged, Lordship.
Yes.
Item number 12. MSC 578 2025. Only respondent is present. You are a claimant. Insurance is
Claimant.
not present.
Can you take the matter after some time?
Yes, yes. After some time. In item number 12, after some time. Yes.
May please, Your Honor. My lord, at page 51 is the impugned order, my lord. That is an interim order, my lord. An injunction granted, my lord, in favor of the respondents. We, the appellants, my lord, are the plaintiff. We are the, my lord, respondent in the court below, in the trial court, my lord. What has happened, my lord? We have entered into an agreement for sale. We are the owners, my lord, having right title possession, my lord, of the land. And the prospective respondent, my lord, they are the, my lord, buyers, prospective buyers. What has happened, my lord? Just crux of the matter, my lord, in 2 minutes, my lord. An agreement was signed, my lord. That agreement is at page 56, my lord. Here, lordship will see it
Page
was
51 is the impugned order.
impugned order. That is the ad interim injunction, my lord, granting that plaintiff would not be disturbed from their peaceful possession of the land and all these things, my lord. But, my lord, just key points, my lord. Agreement for sale, my lord, has already expired. Within that point of time, my lord, 62 lakh was the consideration amount. 5 lakhs were paid, admittedly, my lord. 57 lakhs yet to be paid. Agreement, in the agreement, my lord, it is an unregistered, even not notarized.
You have paid.
No, I am the buyer, I am the seller, my lord.
Seller, okay.
To me, it was paid.
57 lakhs yet to be paid.
Yes, yet to be paid. And the agreement is an unregistered one, my lord.
Okay.
And my lord, in the said agreement, there is no clause of handing over possession. At the event of this, possession will be handed. There were no clause. Now,
So you have accepted 5 lakhs.
yes, we have
But
accepted.
you are not getting the remaining 56.
Yes, I have stated that, my lord, 3 checks were sent over mobile phone, my lord. Not even physically handed over. Now they claim that we have not accepted it. So these are facts, my lord. Now, what has, my lord, why we are before your lordship is this, my lord. The plaintiff in their plaint have stated that they have been in possession, they have taken possession, they were in possession, and in view of the possession, my lord, there were disturbance from our side to get them out. So they have filed an injunction for not to disturb their peaceful possession. That is only in the pleadings. Now, my lord, first point, my lord, we have disputed the possession. We have never given that possession. They have tried immense time to take possession forcefully, my lord. We have approached the authorities one by one. I have annexed several FIRs were filed.
Those checks were sent through mobile.
Through mobile, my lord. And they said, my lord, that we have not accepted it. And when we checked their balance, my lord, I have stated this on affidavit, my lord, only 300 rupees were in their in that bank account, where the checks has been, my lord, shown to have been given to us. Only 300 balance were there. My lord. Now, where the crux of the matter, my lord, where this particular order is, my lord, erroneous. Number one, my lord, we have yet to receive 57 lakh. Only 5 lakh has been given to us. And the Honorable Learned Trial Court should have given an opportunity to us to be heard on that point. Conferring possession and saying that peaceful possession won't be disturbed. This is, my lord, not in accordance with law,
So
because
this injunction order was passed ex parte.
ex parte, my lord, that is where we are agreed. My lord, number one,
This is, I think, status quo order or injunction.
no
order.
injunction, proper injunction, my lord. Said no peaceful disturbance and all these things, my lord. Now, my lord, only two legal points, my lord.
Mm.
Registration Act, your lordship knows, under section 17, a particular tangible property over 100 rupees has to be compulsorily registered.
Mm.
And the TP Act, my lord, Transfer Property Act, these are two legal, my lord. Section 17 is not complied. To have a prima facie satisfaction of the learned court below, that possession was handed over, since we are disputing it. Section 17 says, my lord, compulsorily registered, it should be registered before 100 rupees, and followed by section 54 of the Transfer Property Act, which
This
says,
is not transfer, this is agreement.
yes, my lord.
Mm.
So to make a delivery of the possession, it
Okay, it was
yes,
already
that
handed
is what
over
I'm
for
saying.
this.
It has to be registered, it has to be compulsorily a registered deed in accordance with section 54.
okay.
And 55 also says that, my lord, 55 1F.
Okay.
Yes. Now, my lord, I pray before your lordship at this stage without going much into that, because we are disputing, my lord, my lord may kindly see the practical aspect also. Only 5 lakhs has been given to us with a premeditated intention that they will take over the position and they will fight a civil suit by taking this. My lord, if this is allowed, my lord, directly affecting the seller, my lord, because neither 57 lakhs is yet to be received, my lord, that is a fact. They have also, in the plain talks, have admitted that. They said we refuse. My lord, they have sent over phone, how can we receive? And when we check, it is 300 rupees, that is on record. So these things would have been considered by the court below. We should have been given an opportunity to be heard. So at this stage, my lord, I only pray before lordship. At this stage, this may be kept in abeyance, and we may be given an opportunity, and this particular order may be modified. That much.
Let's go to the order.
Yes. Page 51, my lord.
You are a defendant.
We are defending it in that case. My lord, paragraph number 11 would be, I think this would be enough, my lord. 11 says, my lord, hence an ad interim order is passed against the OP restraining the opposite party defendants, chairman and agents, serving servants, representatives, etc. from disturbing the peaceful possession of the petitioner over Schedule A land, also restraining them from alienating the said Schedule A land.
Where are you reading?
My lord, I am reading at page 54, paragraph 11.
No, I'll go to the entire order.
Entire order, my lord. Entire order. My lord?
Sit down, I'll read
Yes,
it.
my lord.
What is your prayer?
My lord, my prayer, right, as we have not been heard in the trial court, my lord.
Okay.
So that application under section order 39 may be passed after hearing us, my lord. And my lord, this order may be, my lord, has to be kept in abeyance till then, my lord. Because we are not able to put our side, my lord. Because we have, my lord, just one legal part, my lord. 55(1)(f) says that, my lord, it is the duty of the buyer to hand over the possession. And we have not done so, my lord. So at least, sorry, seller, my lord. Yes. It is the seller is bound, my lord, to do that. But since we have not done that, my lord.
So why instead of approaching the trial court, you have directly come here?
My lord, as an appeal. Appeal, because my lord, we first.
Notices were issued to you. This is not a final order.
Not, but my lord, since there is an appellate, my lord, relief, my lord. Because, my lord, there are some pecuniary.
For SR and written objection.
Pecuniary jurisdiction, my lord. We first approached the district judge, my lord, learned district judge. But since the amount is in the higher state, this honorable high court would have jurisdiction.
Unlimited jurisdiction, district judges?
No, my lord, we have been told that that amount.
50 lakhs.
Yes, 50 lakhs. So above 50, since it is 62 lakh, so we have again preferred the appeal before your lordship. But my lord, that injunction part, my lord, why we are saying that ad interim, that honorable, that learned trial court has already made up the mind, my lord. So if it is, my lord, will be in prejudice, my lord. If it is, it will go like this because we have to
dispose it of, then you appear?
Yes, my lord.
Means I won't keep anything in already this order. I'll keep in abeyance for a time till you appear.
Yes.
Submit your written
Yes,
objection.
yes.
Okay.
And my lord, kindly, that has to be, my lord. After hearing us, a fresh order has to be passed, my lord. Whatever, my lord. If it is against terms also, we do not mind, my lord.
Please give me the book. You're referring to 54(1)(f).
Yes, my lord. I am referring to three particular law points, my lord. Section 55(1)(f) of the TPA.
Transfer property action division. Section 55.
1(f), my lord. It says that the seller is bound to give on being so required the buyer or such person as he directs such possession of the property as his nature admits. So we
Transfer
have to
property.
give the possession, my lord.
Heard
And
learned counsel, your name?
my lord, T.H. Hazarika.
Heard learned counsel, Mr. T.H. Hazarika, for the petitioner.
Yes.
For the appellant. This will be
Appellant.
appellant, no?
Appellant.
For the appellants, Riazur Rahman, Najibur Rahman, and Abdul Samad.
Yes.
And Abdul Samad, Fatima, Yasmin Bora, and Bobita Begum Chaudhary. Full stop. It is submitted on behalf of the appellants that they are highly prejudiced by the order dated 5/12/2025 passed by the learned Civil Judge Senior Division.
Yes.
Civil Judge Senior Division in title suits in Midjay case number 1136 of 2025, arising out of title suit number 751 of 2025, granting ex parte injunction without hearing the appellants. Full stop. It is submitted that the appellants are highly prejudiced as the order passed without hearing them. Full stop. They have prayed for an opportunity to place their submissions. Full stop. It was erroneously held by the learned trial court that the balance of convenience tilts in favor of the respondent, who would suffer irreparable loss if ex parte injunction order ex parte injunction order is not passed. Full stop. the factual matrix of this case is that both the parties enter into an agreement and enter into an agreement to sell two kathas of land pertaining to DAG number 1 of KP Patta number 1 under the Moza Beltola, dispute revenue circle, Kamrup Metro, full stop. Oh no, full stop no. For a consideration of rupees 62 lakhs, full stop. Out of rupee, it is admitted by the appellants that out of rupees 62 lakhs, the appellants who are the absolute owners of the aforementioned parcel of land have accepted and received rupees 5 lakhs from the respondent who was the
Prospective buyer.
who was the prospective buyer of the aforementioned land, full stop. It has been falsely submitted before the learned trial court that the respondent is in possession of the disputed land, full stop. It is submitted that the agreement was a non-registered document and there was no transfer of land by the seller to the buyer, full stop. It is submitted that transfer of land or of any immovable property above rupees 100 is has to be registered as per Section 17 of the Indian Registration Act.
Yes.
Which what will be the year? Forgotten.
Section 17 of the Registration Act, my lord, which says, my lord,
Section 17 of the Registration Act 19 year
1908.
1908, full stop.
My lord, along with the section 54.
No,
of-
yes.
Yes.
Let's see. It is further submitted that the appellants are highly prejudiced as they have been debarred from entering into their own land, full stop. The appellants have vehemently denied that the defendants are in possession of their land, full stop. It is further submitted that it has been falsely submitted by the respondent stroke plaintiff that the respondent had paid rupees 29 lakhs or the respondent had paid 1 lakh extra had been
My
paid.
lord, we do not admit that.
Huh?
We
No.
do not admit. Only 5 lakhs.
Respondent has been paid rupees 1 lakh to the Masjid committee.
No, we have not received that.
Full stop.
And also we deny, my lord, we have never refused 29 lakhs which they have.
The appellants have also submitted that they have never refused to accept 29 lakhs from the respondent, and the respondent was not willing to pay rupees 29 lakhs, full stop. Moreover, on checking the balance of the respondent, it was found that the respondent had only a balance of rupees
300 rupees
300 in her account.
in his
Her account, no?
his, my lord.
In her account, full stop.
His account.
His or her,
His, my lord.
in his account.
Tamim Ali.
It is further submitted that as per section 55(1)(f) of the Transfer of Property Act,
My lord, it will be the seller is bound to give on being so required, the buyer or such person as it directs such
that,
person.
okay. One of the TP Act, the seller is required to give on being, a seller is to give, seller is to give.
Is to give.
On being so required, the buyer, or such person as he directs, such possession of the property as its nature admits, full stop. In this case, the possession of the property was never handed over to the buyer, full stop. I have considered the submission that the respondent is willing to file his written objection and to place
Appellants,
its-
appellants, sir.
Oh, appellant.
Appellants, sir.
I have considered the submission that the appellants are willing to file the written objection in Miss case number 1136 of 2025 and to place their submissions, full stop, thereby considering the entire aspect of the matter, the order dated
Dated 5/12/2025.
5/12/2025 is kept in abeyance.
Yes, it's kept in abeyance, madam.
Hmm.
And
Set aside.
set aside would be better, my lord, because that fresh decision would be there.
Is hereby set aside, allowing the appellants to approach the
Trial court.
approach the learned, appear before the learned trial court and file their written objection and place their submission within 1 month from the date of this order.
My lord.
And from date of this order, and after hearing both the sides, the learned trial court may pass any order which the court
Yes.
deems fit and appropriate, full stop. In terms of the above observation, this appeal stands disposed of.
I'm deeply obliged. My lord, civil judge number 3.
এটা লিখি দিবা হা, without issuing notice, মাজত ভৰাই দিবা, to the respondents, this court deems it appropriate to direct the respondent or appellants to appear and লিখি দিবা. To the,
My lord, civil judge number 3, senior division number 3.
হয়তো লিখি দিবা.
I'm deeply obliged.
হৈ গ'ল না?
May I please your lordship,
Mm.
in item number 14 lordship, kindly matter may be pass over for the day lordship.
Okay. Have you taken permission? Today there was a dispute early in the morning. So without taking permission, that adjournment has been taken. Item number 14.
No,
Have you take-
fresh matter, motion,
Oh, motion. Okay.
motion matter.
Learned Counsel, Mr.
M. Hussain,
M. Hussain has paid for adjournment. Is this matter when do you want?
Monday lordship, 2nd of February.
Monday. Fine, Monday? Okay.
Deeply obliged.
My lord, this is an appeal filed by the insurance company. In this case, was a two vehicle was involved in the accident. The accident took place due to the composite negligence of the two driver, but the entire liability was passed upon the insurer of one vehicle. And another point is that we have challenged the quantum of error also. So appeal may be admitted also by this case.
You will admit the appeal. Yes,
Yeah.
we'll admit it.
But 1/2% of
Yes, regarding stay lordship, stay may be granted subject to deposit 50% of the awarded amount.
50% they'll deposit, company will deposit. You
Aye.
filed the aye? You filed the aye. Okay.
He is appearing for respondent number 1 to
1 to 4.
1 to 4.
They are the claimants?
Yes, yes.
But my lord, I have not.
I shall furnish the.
Okay, okay, okay. Learned Counsel, Mr. Your name?
KK Bhatt.
KK Bhatt is present for the insurance company, and Learned Counsel, Mr. P. Ahmed
PM.
is present for the claimants.
1 to 4.
Claimants.
One to
comma,
four.
Respondent number 1 to 4. This appeal is directed against the judgment and order declared
9/12/2024.
9/12/2024 in connection with
In
MSc
case number
case number
2310
2310 of
Of the-
2015. The insurance company is aggrieved by the order as the entire liability was placed on one insurance company.
That's it.
Instead of despite the fact despite the fact that contributory negligence
Composite negligence.
or this case is a case of composite negligence, full stop. Appeal is admitted. Notices to be issued to the respondents, returnable within 4 weeks. The learned counsel for respondent number 1 to 4 is present, and thus no formal notice is required to be issued. However, copies to be furnished within 3 days from today, or today only you furnish.
Within 3 days.
Within 3 days from today. Full stop. Call for the trial court record. Call for the records, original records from the tribunal.
We have to take upon respondent number 5 and 6.
Yes, I have given. Returnable within 4 weeks, this one, issue notice to respondents, yes. I will hear the learned counsel for the petitioner, Mr. K.K. Bhatto is present. Applicant, Mr. K.K. Bhatto is present. And learned counsel for respondent number 1 to 4, Mr. A. Ahmed, no? L. Ahmed.
P.A. Ahmed.
P.A. Ahmed is present. Full stop. An appeal has already been preferred by the insurance company stroke applicant against the judgment and order dated 9/12/2024 passed in MSC case number 2310 by the MSCT 1 Kamrup M. MSCT 1 Kamrup M. Full stop. The applicant is agreed by the judgment and order as the applicant has been held liable for the entire incident, whereas this is allegedly a case of composite negligence, full stop. The applicant has prayed for stay and suspension of the operation of the impugned judgment and order, full stop. Considering the submissions at the bar, the operation of the impugned judgment and award order is that award dated 9/12/2024 in MSC case number 2310 of 2015 is stayed until further order, subject to the condition that the insurance company deposits 50% of the awarded amount before the registry of this court
Within 6 weeks.
within 6 weeks from the date of this order. Full stop. You want to withdraw the amount?
Yes.
You will file another application.
No.
Here I'll allow in this application. The as submitted by the learned counsel for the claimants, the claimants are allowed to withdraw the amount from the registry of this court after proper verification by the registration. Deposited amount, the deposited amount. Yes. In terms of the above, further order sound, in terms of the above observations, this IA stands disposed of. Disposed of.
May I please? Lordship, appeal for enhancement of award, Lordship. Judgment and order dated Lordship 69/25, Lordship, page 9. Lordship, notice may be issued and call for TCR, Lordship.
This appeal is preferred against the judgment and order dated 16/9/2025 passed by the learned member MSCT Bongaigaon in MSC case number 15 2022, full stop. Issue notices to the respondents returnable within 4 weeks. Call for the original record of the trial courts list accordingly. Right.
May I please, your
Yes,
lordship? My lord?
yes.
My lord, this is a pre-arrest bail application, my lord.
Where is the
This,
PP?
we have called, my lord, in fact. He is not receiving the phone call, my lord. In fact, my lord, this case has been listed on 6th occasion, my lord, today, my lord. After calling the city, today is the 5th day, my lord. On many occasions, my lord, this case
Maybe
has
the
been
city
listed.
is here. Let's wait for some time.
Lord, we have called, but he is not picking up the phone, my lord. Several times we have called. Otherwise, my lord, if your lordship, my lord, kindly goes through the FIR, my lord. Nothing remains in the case, my lord, as I have seen, my lord. This,
No, cannot really.
my lord, but I understand.
Cannot be heard, it's part.
Yes,
Let the other side come.
my lord. Shall wait till that.
Mm.
My dear.
My lord, the substantial questions of law, my lord. We have stated, my lord, at page 6, your lordship will find, my lord.
Okay.
Whether the impugned, may I read? Whether the impugned judgment and decree dated so and so passed by the learned trial court below in deciding issue number 4 in the suit, ignoring the contents of exhibit 1 and thereby holding that exhibit 1, the agreement for sale of the suit land, is not a registered document and it cannot be treated as a sale agreement for any purpose, even for the purpose of collateral evidence, and thereby dismissing the suit filed by the plaintiff, ignoring the provisions, my lord, this is important, ignoring the provisions of section 49 of the Registration Act, read with section 10 of the Registration Act. My lord, section 49 of the Registration Act says, my lord, if I may read, my lord.
Registration Act to asan here? Yes, please read. Yes. Yes.
My lord, I am plaintiff before the learned trial judge, my lord. I filed a suit for specific performance of contract. My lord, there was an agreement for sale of land executed in between the, my lord, plaintiff, that is the appellant here before your lordship, and the defendant number 1 in the suit. Now, my lord, despite our readiness and willingness, the defendant number 1, my lord, on one pretext or other, refused to, my lord, execute and register sale deed, my lord, despite our repeated requests, my lord. Accordingly, we have filed the suit for specific performance of contract under section 20 of the specifically, lordship knows, my lord. Now, the defendant number 1, who, my lord, the seller of the land, the owner of the land, he did not, my lord, appear in the court despite service of notice to him. My lord, she did not file any written statement in the suit. Therefore, under order 8, my lord, rule 5 of CPC, my lord, if the defendant does not appear, no written statement filed, my lord, controverting the statements made in the case of the plaintiff, my lord, then it is presumed that the statement made in the plaintiff, my lord, is admitted.
Under order 8.5.
Under order 8, rule 5 of CPC. Now, before that, my lord, let me read section 49. 49 says, my lord, even if, my lord, for the purpose of filing a suit for specific performance of contract, My lord, a non-registered document is sufficient. Your lordship kindly see 49, my lord.
Yes. Section 49, yes.
Proviso, my lord. Lordship kindly see, my lord. Proviso. Provided that, as your lordship got it, my lord.
Yes.
Provided that an unregistered document affecting immovable property and required by this act of or transfer of property act to be registered may be received. This is important. May be received as evidence of a contract in a suit for specific performance under chapter 2 of the Specific Relief Act 1877. Now that this part of the, my lord, the provisions of law has been ignored by the learned trial judge as well as, my lord, the learned First Appellate Court. First Appellate Court, my lord, in fact, has pointed out the error that has been committed by the learned trial judge. But, my lord, with all respect, the learned Appellate Court has, my lord, ultimately, my lord, affirmed the judgment of the trial court and thereby contradicting, my lord, the judgment, my lord, passed by himself. My lord, I will come to that, my lord. Your lordship kindly see, my lord. This is the provision of law, my lord. An unregistered document, proviso says, my lord,
Your agreement was not registered.
it was notarized, my lord,
Okay.
not registered.
It's okay.
It was notarized, my lord. Therefore, and there is a
where's the
judgment of,
land?
my
Where's
lord.
the land? Land? Is it the land?
Yes, my lord, land.
Where?
Land, my lord, Tejpur town.
Okay, the consideration amount?
1,50,000, my lord.
Really? 150,000 Tezpur town?
For 3 lecha, my lord. The area of
3
land
lecha,
is
okay, okay.
3 lecha, only 3 lecha. My lord. 1 lecha is valuable in this Tejpur town, my lord. Your lordship knows,
Yes.
my lord. Now it is, my lord, the land of value of the land has increased.
Three
In
lecha?
many plot, 3 lechas of land. my lord.
How big would
This
be the area of 3 lechas of land?
3 lechas of she is already in possession, my lord, for last 20 years.
How large will be the area? How many feet by feet?
That will
Meter
be,
by
my
meter?
lord, around 150 square feet,
150 square feet.
200 like this.
150 square feet.
150, 200.
No,
Yes.
that's a huge area, 150 square feet.
No, my lord. 3 lechas of land. 1 lecha is equal to how many square feet? My lord, I have 144 square feet is 1 lecha. Therefore, 144 multiplied by 3. 144 multiplied by 3, it is around, my lord, 300 square feet. 300. I said 150.
300
No,
square feet.
300 square. 300 square feet is a small area, my lord.
Not a small area.
Yes, my lord. 300 square feet, my lord, it is not that much.
It will be more than this, it will be around this room, I think.
Anyway, my lord, whatever it is, but as
That's
per the
larger than this
measurement, my lord, 1 lecha is equal to 144 square feet. 1 katta is equal to 2,364 square feet. This is the, my lord, measurement and area, my lord, that has been calculated by the
The document was
authorities.
not registered.
Well, document is notarized,
And
not
how much?
registered.
1 lakh, 1 lakh.
1 lakh I have paid, 50 I remain to pay, my lord, I will have to pay. I am ready in my pleadings, in my evidence, I have stated, my lord, and it is.
You want to stay?
Yes.
Oh no, you want this to be admitted?
My lord, let it be admitted, my lord.
I don't know. I'll have to go through the judgments. Let's go to the judgment. Trial first, we'll go to the appellate court judgment.
Appellate.
It will explain all.
Yes. Then my lord, second substantial question of law, my lord.
We'll go to the substantial. First, let us go to the judgment.
Correct.
Appellate court's judgment.
Correct.
You sit down, I'll read it.
My lord.
You sit down, it's a long judgment. You sit down, I'll read it.
My lord, I'll relevant para,
No.
I'll
No. It
Yes.
won't work. Relevant para won't work.
From 36 onwards, my lord, it starts the relevant
No.
portion. Your lordship may read it, my lord.
Read
I'll
it.
take my
You
seat.
please sit down.
Yes. It's a self-contradictory, my lord, judgment. Your lordship will find, my lord, with all respect, my lord. The learned First Appellate Court has pointed out all the errors committed by the trial judge, my lord, learned trial judge.
Okay.
but ultimately, my lord, affirm the judgment. That is our grievance. It should have been set aside the judgment, my lord.
These questions of law are at page 6, no?
Page 6, my lord.
Okay,
Page
let
6.
me read the judgment. Just a moment.
My.
Defendant number 1 has passed away, now substituted.
Substituted. But despite service of notice, summon, my lord, they did not come forward to contest the suit. Even then, my lord, my suit has been dismissed. That is very unfortunate part, my lord. There is no denial on the part of the my lord seller.
Let's see.
Yes.
Let's see
But
why.
defendant number 2 is here, my lord. She is, my lord, another person who is, my lord, we have stated in our plan, he is occupying a portion of the land, not this 3 lecha, apart from this 3 lecha. That's why she has been made party.
I don't think there is any substantial question of law.
My lord,
I don't think there is any substantial question of law. Judgment has been, it's a well-reasoned judgment.
no, my lord, the exhibit one, my lord, the sale agreement. My lord, your lordship kindly
You see,
see,
you are in the property,
my lord.
you are in the property.
I was
So when
tenant.
the property has been transferred, it is a immovable property.
It has not been transferred, my lord.
I know
An
it's not
agreement,
transferred.
an agreement for sale.
That
That
is
is
what-
why proviso, my lord.
How are you in the property? How are you
As a tenant,
as a tenant?
yes, my lord. It is there.
Hmm.
She has admitted in her written statement. My lord, PW defendant number 2 also said that my father was residing there as tenant.
No, I know. I
There,
have read
yes,
it,
thereafter I was possessing there as tenant. And in the month of, my lord, the November 2006, 9, 2000, 6/11, 2009, my lord, an agreement was executed.
I'm not finding if you have any substantial question of law.
My lord, there is, because, my lord, section 49 absolutely, my lord, proviso says even an unregistered
You
document,
see that judgment, you have gone through the judgment,
my lord.
you have not proved exhibit one as plaintiff.
I have proved, my lord. The said document I have exhibited, my lord. Now
Again, you
the,
will, again, you will bring evidence, then it will not be substantial question of law, it will be fact.
no, my lord.
Question of
Section
fact.
49, section 49 attracts here because the court says, my lord, this is an unregistered document. Because of unregistered document, my lord, this document cannot be admissible in evidence. That is what the trial
There's-
court as
you
well
see,
as
There is
the,
evidence that earlier one document was executed, earlier
My
one
lord.
document was executed in favor of defendant number 2 relating to the same property.
that is
Same property.
defendant number so 2 said, my lord, she has executed subsequent in my agreement, subsequent to my agreement, I executed, my lord, I as well as the
Not
defendant number,
subsequent, before that.
no, my lord. 12, 11,
That is another
2009.
property. Subsequent is another property and before that is the same property.
6 lectures of land, she claimed that 6 lectures of land, she has executed a sale agreement with the same, my lord, defendant number 1.
You see,
That suit is
I will
pending,
not argue with you now.
my lord,
I will not argue with you.
my lord.
You take a date.
It's your lordship, please, my lord.
I don't find subsequent question of
My
law
lord,
here.
your lordship will find, I will satisfy, my lord. I have the
No.
authority. I'll satisfy, my lord. Even if an unregistered document is sufficient for
Yes,
the
yes.
purpose of,
I'm reading it.
yes,
I'm
my
reading
lord,
it.
for the purpose of
49?
49, section 49. Proviso, my lord. Supreme
I
Court
have
of,
read it and I'm reading it again.
my lord.
You take a date.
My lord, as your lordship, yes, yes. Let us.
List this matter after 1 week, 2 weeks, or I'll give you a date.
My lord, your lordship may fix it last part of, my lord, this
Last part of this
February.
February.
Because
Okay.
March.
A date, one date.
First week of March, my lord.
List this matter on first week of March. Date at 5th of March.
In item 17 also, we have not received the CD lots.
My lord, today is the, my lord, 6th day, my lord. Lordship will kindly fix this matter, my lord, in the next week. Then, my lord, the IO, my lord, will send the CD or he'll be present by person, my lord.
Why this investigation is taking such a long time?
Yes, my lord, this
Oh.
case was, my lord, this petition was listed on 10th of, my
Murder
lord,
case?
November, my lord.
Murder case?
No, my lord.
What
It's a
case?
false case of a commission of, my lord, rape, my lord. Absolutely false, my lord. From the bare perusal of the affair will show, my lord.
Okay, let us call for the CD. CDS call for is not received. We should remind the list the matter on next week.
Next week, my lord.
Will it come on next week?
My lord,
From which Thana?
this Nagaon, my lord, Jajori, my lord. Very near. my lord.
Later part of next week, did you? Nahi banali. On 6th February?
Sixth.
6th.
Sixth. Yes, my lord. Up to date case, that because
Up to date case.
yes, my lord. Deeply.
Lordship, any password limit of the time being?
Hmm?
Time being, Lordship.
Timing?
Yes, Lordship, because about the Thursday.
There's no time at all. Timing.
Senior is an election code number 1, Lordship.
We'll wait for some time. Admission
this
orders.
case- In this case, the service could not be affected through paper publication, Lordship. Because Lordship, as per the court order, we have to take notice to paper publication in Nagaland Times. Because there is no newspaper like Nagaland Times. There is Nagaland Post. Lordship.
Nagaland what?
Nagaland Times, there is no such
No
thing.
newspaper.
So we have to publish in Nagaland Post.
Nagaland Post.
Nagaland Post. That is Lordship.
Okay. Learned Counsel, Mr. K.K. Bhatto is is present for the insurance company and has submitted that no steps could be taken through publication in a newspaper through no steps could be taken by publication through a newspaper as the newspaper News Daily was mentioned as within inverted commas the Nagaland Times instead of the Nagaland Post. Poster. Learned
I'm
Counsel,
for respondent number 1, Your Lordship, the claimant.
your name?
S. Paul.
As per Learned Counsel, Mr. S. Pal is present for respondent number 1. Poster. Notices may be issued through a widely circulated news daily. For example, the Nagaland Post.
Nagaland Post. So we have to publish in the month of February, then we have to file affidavit in the month of March also.
Returnable list the matter March out. We'll fix a date or we'll list the matter after 4 weeks.
No, in the month of March also, it may be.
First week of March,
Lots of
6th March.
obliged.
List the matter on 6th March.
Obliged.
May I plead your lordship? My lord, this case is ready for hearing, lordship. Service is complete.
My lord, this matter has been brought before you lordship by our request, my lord. Only for fixing a hearing date, my lord. In the month of February, any date may be fixed, my lord.
As pleadings are complete, list this matter for hearing positively on February.
February 24 or 26.
March first week, lordship. Or February last, lordship.
Then, my lord, 5th March, my lord. 5th March.
5th March? Is it a hearing day?
Yeah.
Yeah,
Yes, my lord.
5th March, okay. Yes, parties are represented. Liquidity.
Obliged.
Obliged, lordship.
Lord, in this case, what is happened, my lord? Dusty service, there was direction, but actually, my lord, earlier occasion, my lord, Learned Counsel, Puspo Dusty Das appeared, my lord. In IA kindly peruse your lordship, IA 57 oblique 56, my lord.
I to direction.
IA, my lord. I was also directed to deposit there 5,000 rupees. That was deposit. 56. ISC 56 oblique 2020.
Oh, acha. 1921 hoy to.
Yes, my lord. English.
Oh.
Appeared, my lord.
Yes.
And kindly peruse your lordship the order last order, my lord.
Rupees 5,000 to be paid to the.
Yes, my lord. Already deposited, but there is an office note also in the flag mark. They not withdrawn that amount, my lord, and avoiding, my lord. Because my lord, execution case is in the lower court. Only 30 days delay case is pending from the year 2014, my lord. 2014 itself, my lord. Second appeal, miss case, there was delay of 30 days. In between them, my lord, sole respondent has expired, my lord. We took step, my lord. A substitution already done, my lord. And I was directed subject to payment, my lord. I already deposited as they did not appear, my lord. there was, I was directed to replace the correction of the said pages, my lord. In the missed cases, I have corrected and copies are upon him, but they are not appearing, my lord. Subsequently, what is happening? The second appeal also, my lord, it is ready, but how can I, my lord, place there, my lord, the corrected substitution pages, my lord? Because, my lord, missed case first, it has to be disposed of, my lord. Only 30 days delay, my lord. From the year 2014 itself, it is pending. And last occasion, my lord, it was listed in the executing court, my lord, in the before the Lanet court below, it is pending. They appeared, my lord, and saying that no, we are not appearing, but the execution has to be stayed, my lord, proceeded. Preliminary decree, my lord. Only 30 days delay, my lord. Same maybe, my lord, condoned, because otherwise, my lord, the Lord, Lordship, in missed case 30 days. All other missed case substitution petition all disposed of, my lord. Missed case 1921 kindly peruse your lordship. Replace also, my lord, corrected pages placed there.
31 days delay.
Yes, my lord, 31 days.
Let's see. I understand they have not accepted the amount.
But they have, my lord, there is an office note last page kindly peruse your lordship. In the 56, there is a numbers of order of the registry, my lord. Flag marks are there.
Shall I send it for to the Lawazima for service?
Yes, my lord, all everything is there, my lord. That is there in the.
It was already sent to Lawazima.
Lawazima, my lord, possibly, my lord, that is regarding that non-appearance they have mentioned, my lord. And execution case is pending, dear my lord. They have appeared on 21/1/26, and next date is given, my lord.
No. You see, you served a notice. 22/1/2026. Door locked as per local resident address. He can lock jari. He can paste it on the door. Why is not doing that?
No, my lord. The learned advocate who appeared here, my lord, in the earlier occasion, my lord, he told me that, my lord, I can receive the copy. You please send me. I have given him this copy, but he is not filing the Okalatnama. Okalatnama is along with me. I am filing, but he is not filing, my lord. And otherwise, in the case, learned court below, it case is going on, my lord, junior division number 3.
I will record your submission. I will give them a last opportunity.
Yes, my lord.
You also take steps, and then if they don't turn up, then I will pass an order. Okay. Learned Counsel Mr. H. Das is present for the
Whatever applicant, appellant.
for the applicant MC 1921-2014. This application is filed for condonation of delay of 31 days in preferring the what is the
Second appeal, my lord.
in preferring the RSA. Full stop. It is submitted that the respondent number 1 and 2 are avoiding to accept notice.
Yes, my lord.
Full stop.
Copy received on 3rd December 25.
They have received copy.
Yes, my lord. I have given it. Today about P. Das was also on a
It
council.
is submitted that copies were furnished to the learned counsel of the respondents who has not filed their wakalatnama.
Yes, my lord.
Full stop. Despite receiving the copies of this application, the learned counsel has not filed this wakalatnama. Full stop. It is further submitted that the respondents are appearing before the executing court.
Yes, my lord.
And
On
they are
last date.
placing the submission for proceeding with the execution.
Yes, ma'am.
But here in this case, they are avoiding to accept notice. You see, there are ways of serving the notice.
Yes, madam.
This process server's report is not correct. He can paste the notice on the
Because they
locked
have
door.
already sent the address, my lord. Where there was initially they were there. They have also daughter, my lord. I have seen here in the records. She received the notices. But in spite of that, her name is there. Onima Thakuria is there in the records. I have seen, but they are avoiding it. In the records itself, it is evident. In the RSC, Onima Thakuria is there in one record. That's why I engaged her, the learned advocate P. Das, and he also appeared. But subsequently, after substitution, they are not appearing, avoiding. I can place it, my lord. after.
Substitution of which respondent?
Sole respondent, father expired, my lord, thereafter daughter and my lord husband, wife. Dispute between brother and sister.
Now, after substitution of the legal heirs of the sole respondent, the respondent number 1 and 2 are deliberately avoiding to accept notice. Full stop. Office note dated 22/1/2026, 22/1/2026, 1 week ago, or 5 days, 4, 5, 6 days back, reflects that I'll tell you, I'll read it out. No such steps have been received by the section till date.
Yes, last order I have not followed because my lord, earlier occasion he has told me,
You
learned
take steps.
yeah, learned advocate himself told me that no, you need not to take step. I'll file Okalatnama. You just give me the copy, corrected copy. Even the second copy of the second appeal also.
Reflects that no steps have been taken by the applicants. Full stop. However, it is submitted by the learned counsel, Mr. H. Das, that as the learned counsel
P. Das.
Had assured him that he will file Wakalatnama, no steps were taken to stop. Considering all the aspects, the petitioners are directed to take fresh steps to issue notice to the newly implemented respondents, returnable within 4 weeks.
Yes. Then maybe.
And then you submit an affidavit.
Yes, well, I file affidavit.
Returnable within 4 weeks.
Yes, my lord.
Please accordingly.
I also kindly peruse your lordship, 57 IA.
It is it is also submitted by the learned counsel that by IA number, by the order dated 14/11/2022 in IA number 56 of 2020, delay for substitution was condoned with cause, whose of the petitioner has deposited the cause which has not been accepted by the respondents.
I will ask, my lord.
No, please note that 21/1/2026. Respondent number 5, answer ID card received from the respondent number 5 and 19. As the 19 actually died, that's for the office notice. And there's answer notice from some other respondent.
21/1/2006, yes.
2026.
1 to 4.
1 to 4.
Kami to may respondent.
Okay.
Others are performer respondents only.
Land counsel, Mr.
A. Burwa.
A. Burwa is present for the appellants, whose of notice dated 21/1/2026 reflects that answer of notice have been received from the have been received back as pro forma respondent number 5 has left the address without information, and the respondent number 19 has passed away. Full stop. Notices have not been service report here. Service report on respondent number 1 to 4 is awaited. Service report on respondent number 1 to 4 and pro forma respondent number 6, 7, 8, 9, 11, 14, 15, 20, 21 and 26 is awaited. And no steps have been taken to issue notice to respondent number 23. You are for?
I am appearing for respondent number 1 to 4. 1, 2, 3 and 4.
Okay.
They are the main respondents in the second appeal.
Full stop. Today, learned counsel, Mr.
I am D. Thakur.
MD Thakur is present for respondent number 1 to 4.
1, 2, 3 and 4.
1, 2, 3 and 4.
Okay, I have another pair. There's a
List these steps to await for await Likhit, await for service report. This matter on after 2-3.
3 weeks, Lordship.
After 3 weeks.
Lordship, there is another second appeal pending before the Honorable Court between the same parties. That may be tagged, Lordship.
Okay.
RSA
This matter along with which
RSA 87 of 2023.
RSA number 87 of 2022.
23.
23 after 3 weeks.
3 weeks.
It is only a position. 24, 25, 26.
May I please, Your Lordship?
Mm.
Your Lordship, the insurance company is represented, but so far the owner and driver of the vehicle are concerned, service is not yet complete. Your Lordship,
Same parties in all the cases.
in all the cases,
Yes, sir.
arising out of the same.
For
one
respondent one, yes, one.
Your
The
Lordship,
owner and driver is not present.
Your Lordship, in the case is pending in the trial court. In the trial court also, even after service, the owner driver doesn't appear. So since some legal points is only involved in this case, so my prayer is that it can be fixed for hearing by deleting the name of owner and driver.
You want the names to be struck off?
Struck off, Your Lordship,
Okay. All the cases.
in all the cases.
Learned counsel, Mr. D. Mondal is present for the claimant. Claimants. And learned counsel, Miss
National Insurance, D. Hazarika.
D. Hazarika is present for the insurance company. Full stop. It is submitted that certain legal points,
Yes.
certain legal issues are involved in this case, and the names of the owner and driver as respondents may be struck off. Full stop. Considering the submissions at the bar, the names of the owner and driver of the vehicle is struck off from the array of respondents at the risk of the claimant. Okay.
List.
Lordship,
we
we'll call
fix
for
on-
a LCR. You want a LCR or you do not want
LCR
a
is not required.
Okay. It is also submitted that the trial that the original records of a tribunal may not be required for hearing. Also, list this matter for hearing.
Your Lordship.
Lordship may fix
date-
the date. Second week of
Your
February.
Lordship,
It was admitted, no, earlier?
Yes, sir.
I'll admit it if not admitted earlier.
it has not yet come for admission. It's, there is interim order, Your Lordship.
Okay.
It may be fixed for admission hearing if possible, it can be disposed of on that day only.
Also, okay, list this matter for admission. Interim order shall remain in force till the next date of listing. We have fixed the date?
Yes, Lordship. Second
Yeah,
week of
interim order shall
February.
remain in force till then. Okay. 27.
Your Lordship,
Lordship date may be fixed.
Date dilen again?
Second week of February.
Date টা দিয়ে দেখুন। ঠিক, second week of February, sign নিয়ে তখন January. Just a moment. Then 11 February?
Yes,
wait, 11th of February. Let it be on 12th, Your Lordship.
No, 12 will not be a hearing day, I think.
Yes, 12 is hearing day.
Okay, 12 February, okay.
Oblige, Your Lordship.
May it please your lordship. Lordship, they were supposed to file objection, my lord. They have taken time on 3 occasions, my lord, before this,
Today they are absent without steps.
my lord. My lord, if they are not interested in filing objection, your lordship may be pleased to list the matter for admission, my lord.
Your name?
Bijay Talukdar. Bijay Talukdar.
Learned counsel, Mr. BJ Talukdar is present for the petitioner. Full stop. This case was fixed for filing written objection, but the respondent is not represented today. it is submitted that several dates have passed, but the petitioner, but the respondent has not filed objection. List this matter in the admission column.
An interim order is done.
Interim order shall remain in force till the next date of listing. List this matter in the admission column after 2 weeks or 1 week.
2 weeks.
2 weeks.
Addressed.
Okay. 28.
And it's last order, my lord. There is no any direction of the take steps, my lord. And that's why my lord petitioner could not take steps.
তাতে লাস্ট অর্ডার এই গুচি গ'ল নেকি লাষ্ট অৰ্ডাৰ কিবা হেৰি এলচিআৰ কল কৰিছিলে নেকি নালাগে নেকি এলচিআৰ এলচিআৰ কল কৰা আছে নেকি আগতে কল কৰিছে নেকি নাই কৰা ন নালাগে চাগে এলচিআৰ ন হ'ব হ'ব নালাগে yes
Last order, my lord, 18/12/2025, my lord. Though there is interim order, my lord, there is no direction to take steps, my lord. That's why, my lord, petitioner, though petitioner take steps, my lord, that was not reflected in the office note, my lord.
We'll extend the interim order.
Yes.
Learned counsel Mr. A. Mohammed is present and has submitted the steps have been taken, but this has not been reflected in the office note. Okay. So await for service report. List this matter on data DD. Meanwhile, call for the scan copies of the trial court records. Interim order shall remain in force till the next date of listing. Thanks, David.
Okay.
29.
Lordship, I am appearing for respondent. We will file objection in this case. Matter may be fixed next week, any day.
Okay, we'll wait for the objection. Okay. Learned counsel.
Another matter I filed, my lord, kindly that matter may come up along with that matter.
Okay. Learned counsel Mr. M. Borbuya is present for the petitioner X. Full stop. Learned counsel Miss
P. Das.
P. Das is present for the respondent
Yes.
and has submitted for time to file objection. Full stop. Prayer is allowed. List this matter along with which one?
Along with, my lord, another, my lord, I'm giving the number, my lord, by writing, my lord.
List this matter along with case number ... Meanwhile, full stop. Along with ... on. You want a date?
My lord, yes, my lord. Maybe, no. Date by people.
Data reduction. When do you want? 4 weeks? 3 weeks? 2 weeks?
My lord, any date as per her convenience, my lord.
Next week.
Next
Any day.
week?
Next week, any day.
No, you won't be able to file objection on next.
My lord, this is a TRP, my lord, with this.
On 6th, okay? 6th February.
6th February.
It is.
Along with
My lord, it is, my lord, the TRP bracket, in this bracket, my lord, the C 6/2026, my lord.
Post of issue reminder to forward the scan copies of the. Oh, sorry. Oh, no, like no.
My lord, any other, my lord, longer date, my lord, because it will be very short date, my lord.
She wanted to file it next week.
Next week.
My lord. Then I have no objection, my lord. Oblige.
Oh.
Yes, your lordship. My lord, the second appeal was admitted on 23rd July 2025, my lord. In that case, my lord, we have filed, my lord, this one we called frame 3 substantial question of law admitted and records was called for both the courts below. And one we have filed for stay, my lord, that is I 22-3525. We have taken steps to all the respondents, my lord. During pendency of the matter, during the court issued notice for stay, my lord. They have executed the execution case, my lord, fixed on 21st January and next the 13th of February, my lord. If whereas this honorable court has directed issued notice for a stay, my lord, they in the meantime they proceed in the execution process, my lord. So may I please state the completion of the entire respondents, even my lord, respondent 2 to 10, their service is not yet complete. Respondent 1, the principal defendant and respondents appear before this court, my lord. And by the simultaneously they are appearing here and their execution proceeding is going on. Whereas this honorable is specifically directed for staying of application, I am issuing notice returnable 4 weeks, my lord. My humble submission at this today's, my lord, in the I application, my lord, the second appeal, my lord, since record call September,
But what, she's
Interim-
for a senior, I believe, what is to say? She's for a senior, she won't be able to counter your submission. Yes, Lordship.
otherwise, my lord, execution proceeding, tell my lord on Friday, my lord, kindly fix on this
Yes,
matter.
ma'am. Yes, on Friday.
Yes,
Learned counsel, Mr. P.K. Dekano.
yes, my lord.
He is present for the
Appellants.
appellant and learned counsel, Miss
Yes, Ahmed, on behalf
Yes.
of MJ Kadir.
Ahmed is present on behalf of learned counsel, Mr. M.J. Kadir, and is prayed for adjournment. Please this matter on Friday.
Friday.
Mm.
Deeply obliged, my lord.
Made period lordship.
Mm.
As per the office note dated 21/1/2026 lordship. Service upon the respondent number 4 is not complete.
Respondent number 4.
Respondent number 4, 1 to 3 has appeared lordship.
So I'm for 1, 2, and 3 lots.
Lord, for respondent 5, I am
You have for 4.
5.
5.
4 is awaited.
Let's see. Learned counsel, Miss
M. Devi lordship.
M. Devi is present for the
Appellants.
appellant, comma, learned counsel, Mr.
M. Boro Lordship.
M.
Boro.
Boro is present for
Respondent 1, 2, and 3 Lordship.
respondent number 1, 2, and 3, and learned counsel, Mr.
A. Sahad
A.
for respondent of
A.
Sahad, S-A-H-A-D.
A. Sahad is present for respondent number 5. Full stop. Service report on respondent number 4 is awaited.
Lordship.
Please this matter after 4 weeks. Oh,
Lordship.
4 weeks.
33. May it please your lordship, your lordship, this matter may kindly be taken sometime, your lordship. Conducting counsel is on lake.
Sometime, look at the time.
Lordship, he is on lakes in court number 15, your lordship. Item is going on.
Okay, after some time.
After some time.
Okay.
Okay, sir. May it please lordship. Lordship, I took steps, though it is not reflected in the office note.
Okay. Learned counsel, Miss
D. Pathak.
D. Pathak is present on.
Appellant.
Oh, this present, your name is in the first list.
Yes, sir.
D. Pathak is present for the appellant. Full stop. It is submitted, the steps have been taken, but it has not been reflected in the office note. Await for service report. Leave this matter after 2 weeks.
4 weeks.
4
weeks.
4 weeks. After 4 weeks.
I know this.
My lord, in this case,
Mm.
we have filed an application for injunction violation application in the pending second appeal. So let, my lord, other side is not here. Lordship may either, because they are already representing me in this case. I have also,
To hear also now.
that's right. my lord.
If I hear also, I won't be able to pass an order.
So let it be adjourned, my lord. the matter.
Yeah, I will adjourn it.
That's better.
The remaining cases I'll adjourn. I don't think I'll be able to hear and pass any order today, no? Will I be able to pass any order? Only these cases, any cases are fixed for orders only, which are cases are fixed for orders, I'll take up and then the remaining will be left over. Is it okay?
That's all.
Learned counsel, Mr.
P.K. Roy.
P.K. Roy is present for P.K. Roy Chaudhary.
P.K. Roy.
Counsel?
P.K. Roy. Senior counsel.
Learned senior counsel, Mr. P.K. Roy Chaudhary.
Roy, my lord, P.K. Roy.
Okay, I'm sorry, huh? The P.K. Roy is present for
For the appellant.
the
Appellant petition.
appellant. Actually, this bench comes after a long period of time, so I keep forgetting the civil lawyers. Names of the civil lawyers.
That's
Senior counsel, Mr. P.K. Roy is present for the appellants, and respondent is not.
No, they're not
today.
present.
Respondents are not represented today. Please just matter after when do you want?
Let it be after 2 weeks, my lord.
After 2 weeks.
Lordship. Yes.
May please, Your Lordship. As per previous order dated of IA, we have published a notice on newspaper, Your Lordship.
Has been
And-
published?
Yes, Lordship. I have a copy of newspaper, and also I have filed an
No,
affidavit.
you'll have to file an affidavit.
Affidavit filed, not in record, Your Lordship.
Okay.
In record.
Learned Counsel, Mr.
A Pator.
A Pathak has submitted that notices had been advertised through a popular news daily, and an affidavit has been submitted. First of receipt to place the affidavit on record. Use this matter after 2 weeks.
That may be fixed, Your Lordship.
Dated at Dixon, 2 weeks, officer.
Lordship.
Lordship, may take up IA number 3809. Rise for substitution of legal heirs, Lordship.
I have no objection. I have no objection.
No objection. We'll allow that.
Lordship.
Any other?
There is another IA that is 3710 that the respondents had filed to inform us regarding the death of the respondent number 5. So Lordship may dispose that as well.
3710.
3710 filed by us.
Learned Counsel, Mr.
T. Roy.
T. Roy is present for the 3710 likhiba, huh? T. Roy is present for the applicant who has filed an application under Order 22 Rule 10A read Section 151 CPC to communicate about the death of respondent number 5. Full stop. The Learned Counsel Miss
K. Bhattacharya.
K. Bhattacharya is
On
present.
behalf of Mr. G. N. Sahewala.
On behalf of Learned Senior Counsel, Mr. G. N. Sahewala, representing the respondents in this case. The petition, this application is hereby allowed after hearing the submission of both the sides. Okay, this allowed will be sufficient.
Yes.
Itu ulta ke likhi diba, huh? Learned Counsel Miss T. Bhattacharya.
K. Bhattacharya.
K. Bhattacharya is present for the applicant. And on behalf of Learned Senior Counsel Mr. G. N. Sahewala and Learned Counsel Mr.
T. Roy.
T. Roy is present for the respondent Shekhar Roy and others.
Yes.
Respondent Shekhar Roy and others. Full stop. This application is filed to substitute and implead the legal heirs of respondent number 5. The Learned Counsel for the other respondents has no objection. Thereby, the legal heirs of respondent number 5, namely, 4 and 5 or 5?
5.
5.
5. Naam kita ase tate. How many legal heirs?
3, Lordship.
3, yeah.
It is in page number 5 of the IA.
Is allowed to be substituted and added as respondents.
Lordship.
In it will be CRP, no?
Yes, sir.
In CRP number 254 of 2014.
14.
And amended first article to be submitted.
Okay.
List the CRP to decent Kazi. Yalagot. CRP to likhi diba. List this matter after 2 weeks. You'll file within 2 weeks or you'll need
Yes, Your
some more
Lordship.
time?
Lordship, within 2
Okay,
weeks.
all right.
All right.
Lordship, in this case, we have already filed our objection, Your Lordship, but that is not dead. It was filed yesterday only.
Releasing
Yes, Your Lordship, to that we
the
have
amount,
filed our
it is
objection yesterday
deposited
only.
before the registry by
Then
the,
let the objection come.
Yes, Your Lordship.
Learned Counsel Mr. P. Muzumdar
yes, Lordship.
is present for the applicant, and Learned Counsel Ms. P. Bhattakur is present for the insurer and has submitted that they have already filed the objection for solicitor to place the objection on record. List this matter after 2 weeks.
Lordship,
After one
date, after a date may be fixed, Lordship,
date of the deduction.
because
February first week date at a detail.
Excepting fifth, your lordship, sixth.
Sixth.
Actually, I for withdrawal of the statutory amount.
Withdrawal of the statutory, okay.
Statutory amount.
Learned Counsel Mr. K.K. Bhatto is present on behalf of the insurance company and has filed this application for withdrawal of the statutory amount of rupees 25,000 deposited before the registry of this court. We will allow it.
That's it.
Judgment has been passed, no?
Yes, no, it was settled, that's it.
Oh, settlement, okay.
Settlement.
It is submitted that the appeal was disposed of in the local adalat.
Yes,
Huh?
yes.
In the Lok Adalat being MSC Appeal 247 of 2025 in United Insurance Company Limited versus Sunita Teronpi and others. Full stop. The appeal was both the parties have arrived at a settlement. Full stop. Thereby, the annexure 1 is the copy of the appeal, a copy of the order in the appeal. Full stop. Considering all aspects, the petitioner applicant is allowed to withdraw the statutory amount of rupees 25,000 from the registry of this court. In terms of the above observation, this I stands disposed of.
Wait, please, your lordship. Your lordship, this matter has come up for the first time. Lordship, here there is only delay of 5 days. Your lordship, may condone the delay. Delay of only 5 days.
We can condone, let us issue notice.
Lordship, there is also execution going on in this case. We have some urgency, your lordship, so we have to get the stay at the earliest, your lordship.
Learned Counsel Miss P. Bothakur. P. Bothakur, no? Is present for the insurance company and has admitted that the delay was not intentional. Full stop. A prayer has been submitted to condone the delay in preferring the appeal against the judgment and order dated
28/5/2025
in connection with MSC case number
42 of 2023.
So it is submitted that there is some urgency.
Lordship, we have received execution notice, your lordship.
As they have received, as the insurance company has received execution notice, full stop. The delay is only for a period of 5 days. Full stop. There was no malafide on the part of the appellant. Full stop. The judgment was delivered on 28/5/2026 by the learned member MSCG Tinsukia. And the appellant learned about the order on appellant learned about the order on 23/7/2025, and thereafter there was and this resulted in the delay. Full stop. Considering the submissions at the bar, it appears that delay may be condoned. Full stop. Thereby delay may be condoned. Registered a connected appeal.
Your lordship, it may be fixed for admission
Delay is
next week,
condoned.
your lordship. Next week, any date?
Huh?
Next week, your lordship.
Or thereby delays condoned registry to register the connected appeal on the next week.
Next week, your lordship. Can a date may be fixed, your lordship?
Cannot, you'll have to pursue in the registry.
Oblige, your lordship.
May I please?
Yes,
Let me
yes.
take up that the IA 116 of 2026, the delay in filing the appeal 130 days delay.
You have to issue notice.
Yes, madam. This is an appeal by the owner.
I understand. Learned Counsel, Mr.
P. Hazarika.
P. Hazarika is present. Issue notice to the respondent, returnable within 4 weeks.
Well, 3 weeks.
Returnable
Because we
within
have
3
received
weeks.
the execution notice.
Okay, returnable within 3 weeks, list accordingly.
My lord, service by registered post.
Not registered post, speed post, no?
Speed.
Mm.
Now it is.
Notices may be issued through speed post.
My lord. Public.
Yeah, please, your lordship.
Mm.
Yeah, please, your lord.
First appeal orders. Everybody is present.
Yes, sir.
Yes.
We'll list it for admission.
R2, I have admitted, R2 it will be on. Respondent service is not yet completed.
Respond number 2.
Lordship.
You have for respond number 1 only.
Yes,
Okay.
Sole
You have
respondent.
you have submitted Okalan number.
yes.
Okay.
My
Sole
lord,
respondent.
sole respondent. My lord,
No, in fact, two, respondent 2 is not yet.
Huh?
Respondent statement.
we are for
Present
respondent
with the
number
owner.
1, my lord. My lord, the last date order may kindly be seen.
Mm.
In this case, IN on
Mm.
IN on 3442
Mm.
of 2025. Order dated 16/12/2025.
Mm.
That may be looked into. Appeal was admitted, my lord, after condoning delay, appeal was admitted subject to deposit of 50% within 4 weeks. 4 weeks period has expired on last
They'll
14th
deposit.
January.
Don't worry.
I'll take instruction on this. I don't know. Next week, maybe after 5th.
Learned Counsel Mr. R. Goswami is present for the appellant and Learned Counsel Mr. A.
J. Mullah,
J. Mullah is present for the respondent number 1.
1.
Service report on respondent number 2 is awaited.
Everything.
It is submitted by the Learned Counsel Mr. J. Mullah that the order of I number 3442 of 2025 has not been complied with and compensate 50% and done and 50% of the compensation has not been deposited. Post of Learned Counsel Mr. R. Goswami has submitted that he will obtain instructions. List this matter after 4 weeks.
Yes, sir. Correct.
You kept something for time being, no? Let us finish it.
Item number 33.
33, Lordship.
33. Let us finish it. 33.
Lordship, in this case, the LCR has come.
Oh.
So it can be fixed for hearing after even 2 weeks. In the meantime, my learned friend is pressing for interim me. But the matter can be disposed.
50% deposit, lordship, death case, lordship. And
Today I cannot hear you. It's already 3. So let us fix it for hearing. And
for hearing of the on the interim, that IA.
We'll fix it
Final.
No, lordship, hearing on the IA, lordship.
We'll fix it for orders then. We'll
For
fix it
orders, yes, lordship. 124.
Parties are represented, LCS before us. List this matter
24/2.
on 24/2.
24/2.
For disposal. Lordship.
No, lordship. For
No, in the orders column.
that's one. Because my C cross objection is also there.
In the orders column. Okay.
Lordship.
Are was saying, no? This will be a long matter, so we won't be able to finish it today.
Yes, yes.
This he will raise objection. He is not willing